Hello, everyone, and welcome back to Uncivil Law, where, as always, we learn from the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and we are here with our continuing coverage of the impeachment trial of Ken Paxton, the Texas Attorney General. Ken Paxton is accused in 16 impeachment articles of various misdeeds, principally relating to apparent misuse of his office to benefit a friend. So he had someone who he was showing benefit to in a way that showed graft. This person that he apparently was showing preference to was a real estate developer or wannabe real estate developer in Austin, but apparently things were not going very well for his business. He was in trouble financially. And so the allegation is, generally speaking, that Ken Paxton used the facilities of his office to assist his friend by, for example, preventing his businesses from being foreclosed on, and by going after his competitors, and also that he retaliated against his own staff who attempted to blow the whistle, among other related charges. And also that he tried to settle a personal issue using governmental money. So basically using governmental money for a personal purpose, otherwise known as embezzlement. So these are the charges that are sort of proffered against him. So far, we have heard the witnesses. So far, we've heard the senators be sworn in one at a time in a somewhat painful and laborious fashion. Then we heard the charges, some motions that were levied, all of which were denied or had already been previously granted. So there was nothing to do. Both sides get 1 hour for opening, 24 hours for presentation of evidence, and I believe 2 hours for closing arguments, so they get 27 hours each. So we're going to be here for a hot minute trying to deal with this as we deal with all that stuff, so good times. So we'll see. The motions to dismiss were denied by varying vote counts, but, you know, some of them are not looking super promising for Mr. Paxton. We need 21 votes to convict him, 2/3 to convict, and depending on, you know, there at least are the votes that are there. So we'll see. We'll see. But, you know, it's a long way to go, but things are not looking super duper promising. So we'll see how it goes. And that's what we're doing. All right. We also have the witnesses sworn in, so there will be some witness testimony, I guess. So we'll see how that all proceeds. I'm just interested to see how it will all pan out as used. So we'll spend the next 2 hours in opening arguments, I guess. And then, so that will start at 1, so that will get us to about 3 o'clock. And then they're supposed to be there till 6. So I guess we'll get the first 3 hours of the presentation today. So we'll see. That is all the things that are happening right now. The House vote of 121 to 23 to bring the impeachment articles also not super encouraging. So, we'll see. Can you get 21 votes? Maybe. Maybe. Thank you for the 175 of you who are turning in. I need to update the Twitter link, so let me go ahead and do that while I'm thinking about it. I need to give you a new link. I gave you a new link for the retweets. Retweet, please. So for those of you who have the Twitter, if you could retweet that link, that would be very helpful to help bring some attention to the channel. Henhouse says you made homemade loaded nachos. That sounds nice. Yeah, calling it X doesn't exactly roll off the tongue, does it? Good morning from New Zealand. Hello, New Zealand. How is life treating you in New Zealand? I would like to visit your country someday. It looks nice. Off just all by yourselves, floating alone in the ocean. No neighbors for miles and miles and miles. You made iced coffee? That sounds nice. Hmm. So we're just waiting for this thing to get started back. Should be starting in about 6 minutes. Also, there's technically 4 charges that are still in abeyance. So hypothetically, we could be doing this impeachment thing again at some point in the future. So that's an interesting way to go about it. The impeachment that never ends. Iced coffees, I want coffee, but I don't want to wait to drink it. Where's the hat? I'm feeling a little warm. So I took off the hat because it holds in heat. What am I drinking at the moment? Nothing. I got some tea, though, by the side. Paxton issue is only criminal at the moment. He's got criminal charges pacing, but this is political. I tend to agree. Iced coffee is the only coffee. I have great patience. Yeah. I have a tolerable amount of patience. To the 200 of you currently watching, just waiting for this thing to get started, thank you, by the way, as you watch nothing but my ugly mug on your device of choice. You can watch me in glorious 1080p. Good afternoon, Stacy. Thank you, Sula, for saying I'm great. I appreciate that. I try to bring a good quality educational and entertainment product to you. I appreciate every one of you here. Move to Houston, just don't drive. This is day one. Yeah, this is day one of the proceedings. We're going to be here for a while. Maria says you love watching me and Natalie, 2 different perspectives. Yeah, I like it for that reason too. I like it for that reason too. You have an unrelated legal assistance question? I can't answer personal questions. I can't give personal legal advice. The best I can do is answer generic questions. I can't answer anything that's applicable to a particular person, because everything is going to depend on a whole bunch of situations. It's impossible to give meaningful legal advice on a stream like this, because you have to ask so many questions to make sure you get the right answer. You're at a dead stop on traffic in the mountains in northern Georgia. What's up, Uncivil? Well, I hope that you will be able to get through traffic pretty soon. You just need to try to obtain an old court transcript. Well, you're probably the best place to start is with the clerk of the court. They would be the best place to start because they would have knowledge of where to look for such things. And if they don't have it, they would presumably be in a position to direct you to the right place. So if you need a transcript of a court proceeding, I'd try the clerk of the court's office. Most of them you can email. Be like, would it be possible to get a transcript of this? It'd be very helpful if you identify exactly what it is and exactly what it was, what thing it is. So I'd like the transcript of the hearing that occurred on this particular date in this particular case. The more information you give them, the more helpful it will be. So that'd probably be your best bet. Yeah. Try with the clerk of the court. It'd be helpful. It'd be more helpful. The more information you can give to help them identify exactly what you want, the better. It's like, if you know the particular judge's name, if you know the case's name, if you know the official case number, the date, the specific date of the hearing that you're interested in, or stuff like that. The more information you can give them, the more helpful they can be in terms of giving it to you. Yeah, $150 for a pretty simple transcript. That sounds about right. $150, yeah, depending on what you're looking for, could well be. I mean, to spend, especially if you're on an old transcript and it's going to take time and effort to identify. Yeah, it might well be. And then you got to pay for the pages of it. Sure. Yeah, it might well be. Thank you for saying you like the blue shirt. A lot of people think that my thing looks good. Why do you keep looking at the kitchen area? I don't know. There's not very much to look at. It's just a kitchen. My back shelf here probably needs a little bit of help with some of the stuff that's on there. So it's a little bit cluttered back here right now. But otherwise, it's a perfectly normal kitchen. Nice lighting, thank you. I do like the lighting that we've got set up with the 3-tone. We've got the color. We broke up the color wheel to make the colors look nice. In the triad and the color wheel. So we broke up the color wheel and made 12 different triad lighting settings so they'd all look nice. We did a little bit of color theory. Stacy, I'm doing fine. Thank you for asking. Have I tried any new recipes? No, not lately. You just break out the color wheel and do a little triad, right? You just pick 3 points in the color wheel that are all as far apart from each other as they can possibly be, right? So you pick 1 point in the color wheel, and then you just draw a triangle, and then you have 3 parts that are all equally as far apart from each other as they can be simultaneously. It looks nice. I've never heard of Bourne, Texas. So no, I've not checked it out. Is there anything else you've interesting? No, not so much. Nothing interesting has happened so far. It's all been preliminaries and procedural stuff this morning. So nothing of interest has happened so far. Except Ken Paxton pleading not guilty, I guess, was the most interesting thing of the day. And his attorneys finding creative ways to plead not guilty. Some of it he found scandalous. Others of it he found objectionable. Still others he found without factual or legal basis. Yeah. One time he pled absolutely not guilty. I'm like, okay. It's like, as opposed to what, I guess. But yeah, basically doing an O.J. Simpson over here, absolutely 100% not guilty. I'm like, okay. It wasn't a good look for O.J. It's not a good look for you, man. The headphones on my neck look like a trach. I could break it so it's not like right up against my neck like that. So I could do it like that. So they're not like closed off. How about that? It's pronounced Bernie? Okay. Was it Orwellian 2 Minutes of Hate? Nah. I don't think it was that. I don't really like humid. See, that's the thing. I don't really like humid. So Houston may not be the place for me. I don't know if I can do Houston. I don't really like humid. Hot is fine. Humid, not so much. And don't go to Houston? Okay. Maybe I shouldn't move to Houston then. Maybe it's Fort Worth for me. We'll do a little poll in the chat. What do you guys think? Fort Worth or San Antonio? We'll do a poll. I think last time we did this it didn't, it came out basically as a tie. Which Texas is best Texas? Your choices are Fort Worth. We'll say Dallas, too, or San Antonio. All right, let's see what you guys say. Get used to the humidity in Houston? I don't know, man. Sounds brutal. I'm still waiting for this thing to start. They're running a little bit late. They're running late. Let's go. Trials restarted. Yep. All right. Cool. Thank you. You loved Houston after you moved to Seattle? That's an interesting comparison. Those are two very different places. Why am I looking to move? Well, the idea was being closer to Nate the lawyer who lives in Houston. Being closer to him, and we would be able to, do stuff together. And so basically it's an even split on the question of which Texas is best Texas. Split down the middle. Nate moved. He lives in Houston now. Yeah, Nate lived in New York for a very long time. He moved recently. He lives in Houston now. How's it going? It's going all right.
Mr. Hardin, Mr. Murr, please come to the bench. Please approach.
Yes,
Mr. Hardin.
sure. Oh, up here.
Well. And we have asked, for the record, the Paxton team, counselors to come forward.
Nice place to live is like a nice picnic. It always starts out good and ends up being covered in ants and bees.
I will address, and members, let me just not remind you, but when we're meeting at the bench, the jurors may not come up to the conversation. I'll rule on your motion as they come up. And members of the jury, I want to remind you that statements made in the opening statement is not evidence, and it's an outline of what they're going to present. With that, Mr. Murr? Yes.
Having a hard time hearing. Those mics are lower. I don't think they were intended maybe for them to be standing at the table talking. That if you could make sure that for those of us who have a hard time hearing in this chamber, that they try to be closer to the microphone.
Yes, Senator. The requirement was to be sitting at the mics at the table, not standing. So when you come to the podium, you can stand, but be sure you get into the mic, because the echoes in here are very difficult. Thank you. Mr. Murr, you have 60 minutes.
Mr. President, Senators, today is an important day. On this day in 1836, Sam Houston, whose Bible you used for your oaths today, was elected President of the Republic of Texas.
I didn't know that. That's a cool factoid from history.
Today is also an important day because we begin this impeachment trial. While impeachment is rare, the drafters of our state constitution recognized that there are times when this extraordinary remedy is needed to protect the state and its citizens from a public office holder who has abused the power of his office by putting self-interest above that of the people of Texas. The drafters concluded that this great deliberative body, the Texas Senate, is best positioned to determine when this remedy is appropriate. Earlier this year, Mr. Paxton came to the legislature seeking $3.3 million in taxpayer money to settle a whistleblower lawsuit. Mr. Paxton would not answer any questions about the underlying claims. He had successfully blocked any discovery in the case for almost 2 years, and he refused to justify the settlement. The House investigated the serious allegations raised by the whistleblowers. The House uncovered egregious misconduct and abuse of office by the Attorney General of the state of Texas and voted overwhelmingly to prefer articles of impeachment to the Senate. This is why we are here. The allegations in the articles reveal that the state's top lawyer engaged in conduct designed to advance the economic interests and legal positions of a friend and donor to the detriment of innocent Texans. Mr. Paxton turned the keys of the Office of Attorney General over to Nate Paul so that Mr. Paul could use the awesome power of the People's Law Firm to punish and harass perceived enemies. I was raised in rural Texas, where a person's honor is more important than money, where integrity matters, by a family deeply affected by political corruption. This is precisely the type of grave official wrong that our Texas Supreme Court has said warrants impeachment.
I like the way he's starting.
My grandfather, who was privileged to serve the state of Texas for many years, had a favorite quote from Abraham Lincoln. Nearly all men can stand adversity, but if you really want to test a man's character, give him power. Mr. Paxton has been entrusted with great power. Unfortunately, rather than rise to the occasion, he has revealed his true character. And as the overwhelming evidence will show, he is not fit to be the Attorney General for the state of Texas. Mr. Paxton argues that the Senate should not exercise its constitutional duty to decide whether his conduct merits impeachment, because voters were aware of the allegations and still re-elected him. He claims that the Senate should abide by the alleged will of the voters. However, this ignores the intent of our framers of the Constitution. Impeachment was included in the Constitution after the Founding Fathers debated and rejected the idea that elections could singularly protect the public against abusive office holders. In other words, drafters agreed that impeachment was and is necessary to protect against abusive officials because it was simply too easy for them to use the powers of their office to conceal the truth until after the next election. The concept of the forgiveness doctrine is not in our Constitution and does not apply here. The courts have made that very clear. And even if it did, the doctrine presumes that voters know all the facts. The voters did not and do not know the whole truth. Mr. Paxton went to great lengths to hide his misconduct from the public. The evidence will show that he used massive resources of his office to prepare and issue a sham report that allegedly exonerated him. The evidence will show that this report contains false and misleading information about the allegations against him and about the whistleblowers themselves. And he also lied about the independent nature of this investigation. Documents will show that he played a key role in drafting that report. The Constitution says the Senate has the power and the duty to decide this case and to protect the people of Texas from someone who has violated his oath and has shown he does not respect the law. The witnesses and the evidence will show you that Mr. Paxton's conduct merits the exercise of that power. And the witnesses and the evidence will show and prove beyond a reasonable doubt that he should be removed from office and prevented from ever holding a position of trust in the state of Texas again. Mr. Paxton argues that the articles do not allege impeachable conduct because they do not allege that he committed a crime. We do allege that he committed crimes. We have detailed that Mr. Paxton received favors, including home renovations and help in concealing and continuing an extramarital affair, in exchange for the Office of Attorney General punishing Nate Paul's enemies. However, we don't have to show some type of quid pro quo to establish that his conduct should result in impeachment. As the Texas Supreme Court made clear regarding the impeachment of Governor Ferguson 106 years ago, wrongs justifying impeachment don't have to be crimes.
I like his cadence.
Justifying impeachment are
I like his tone
than that because they have
I like
the
his
purpose
energy
of protecting the state.
He's got a good
not
voice that
punishing the
carries.
offender. Mr. Paxton
He's got a kick-ass
should be removed
mustache.
from office because he
It's
failed
like
to
plus
protect
credibility
the state
right there.
and instead used the power of his elected office for his own benefit. And this was wrong. The oath of office that we all took to protect the citizens of state and to uphold the laws of this state and this Constitution means something. It isn't just words on paper. It's literally an oath to God.
Nice.
And Mr. Paxton had an obligation not to abuse his office for his own benefit. He betrayed his constituents and the sacred public trust that's been given him. And in Texas, we require more from our public officials than to merely avoid being a criminal. The witnesses you will hear from are remarkable people. Until they refused to follow Mr. Paxton's wrongful demands, they were his most trusted, hand-picked advisors, and they believed in his conservative mission for the office of the Attorney General. The problem isn't that their commitment to conservative governance changed. It is at the end of the day, Mr. Paxton wasn't the man they thought he was.
Nice.
And he wasn't the man he publicly...
Oh, yeah, no, he definitely needs a bolo tie for sure. I agree, Matthew.
His trusted
100%.
advisors are not rhinos or part of some deep state storyline. They are movement conservatives guided by their faith. These witnesses will explain step by step how they discovered that Mr. Paxton grew increasingly intent and passionate about helping his partner, Nate Paul, escape civil and criminal legal troubles that he was facing. They will describe in chilling detail when they connected the dots of Mr. Paxton's slow creep of corruption. The senior staff were outraged when they discovered that Mr. Paxton had directed a young, inexperienced outside attorney to obtain grand jury subpoenas to harass and interfere with an ongoing criminal investigation. Subpoenas that had been improperly issued to DPS officers, a federal judge, attorneys involved in a civil lawsuit against Nate Paul, and even court staff. And the subpoenas sought intensely personal information, including cell phone and email records. Now, I'm not going to detail in this opening all the allegations against Mr. Paxton. You're aware of many of them. You sit as a unique jury, having known Mr. Paxton and familiar with some of the facts. But even a quick summary of some of the evidence that you're going to hear is shocking. One of Mr. Paxton's many acts of deceit involved a member of this chamber. At a time when the policy of the state was Texas is open for business during COVID, Mr. Paxton directed his staff to issue a legal opinion advising that statewide foreclosure sales not move forward. Mr. Paxton was adamant that the opinion, which came to be known as the midnight opinion, be issued before the end of the weekend, just in time for Nate Paul to use it to avoid a foreclosure sale the following Tuesday. This conduct benefited Nate Paul, and it harmed businesses and people impacted by foreclosure. Mr. Paxton also used the power of this office to harm a charity solely to benefit Nate Paul. The Office of the Attorney General is charged with the responsibility of intervening in lawsuits when it's necessary to assist a charitable organization. As you'll hear, the first and only charitable case Mr. Paxton took a personal interest in was the Mitty Foundation's lawsuit against Nate Paul's entities as an investor. The evidence will show that Mr. Paxton directed his office to intervene in the lawsuit, to stay the case, and allow the AG's office the opportunity to pressure this charity to accept a lowball settlement offer. This would have saved Nate Paul millions of dollars. The creep of corruption continued when Nate Paul wanted access to confidential investigation materials related to police raids on his home and businesses. In an attempt to learn what the police knew and how they knew it,
Nate
Mr.
Paul
submitted
is the
open records
Texas
requests
landlord
seeking the full police file.
real estate developer who
Even though no
Paxton
police
is
file
accused
may
of
be disclosed
helping
due to the
through his
well-established
office.
law enforcement exception, Mr. Paxton pressured his deputies to authorize the release of this information. Had he succeeded, Mr. Paxton would have created precedent allowing any person under criminal investigation, whether for a violent felony or a sex offense, to obtain confidential information about the investigations of their conduct. Mr. Paxton simply did not care that his request to release information to Nate Paul would have put police and victims across the state at risk. Unfortunately, the House investigation revealed that Mr. Paxton's relationship with Mr. Paul was far more extensive than even his closest advisors knew. Over the course of 3 months, Mr. Paxton personally met with Nate Paul more than 20 times. Many times, Mr. Paxton would ditch his security detail. And Nate Paul even set up a secret Uber account that allowed Mr. Paxton to secretly visit Nate Paul and others. To conceal his efforts, Mr. Paxton communicated in off-the-book ways, using burner phones, encrypted messaging apps, and secret email addresses.
Ooh, fun.
Mr. Paxton's brazen abuse of the Criminal Justice Division at the Office of Attorney General is finally what caused 8 of his senior staff to report him to the police. The question that haunts them and should frighten all of us is what would have happened if they had not reported him? How far would Mr. Paxton have gone in using the power of the Attorney General's office to harass and punish his and Nate Paul's perceived enemies and hurt innocent Texans? Mr. Paxton tries to defend his actions by isolating each event and claiming that standing alone they can't support impeachment. You cannot and should not view each act in a vacuum. The evidence will show that they are all connected. They're all connected by Mr. Paxton and his desire to deliver for his partner, Nate Paul. Mr. Paxton will also argue that the acts represent differences of opinion on policy or efforts to help a constituent. But the witnesses will explain to you that Mr. Paxton's actions have nothing to do with implementing conservative policy. And in fact, his efforts violated those very principles. Mr. Paxton's senior advisors were fully aware of the dire consequences of reporting him to law enforcement. They knew retribution would be swift and vicious. The choice they made to report him to the police was one of the hardest of their lives. But they will tell you that there really wasn't a choice at all. Sam Houston, who on this day in 1836 was elected president of a new and free republic, reminded Texans, do right and risk the consequences. Do right and risk the consequences.
Nice, not bad.
Doing the right thing is sometimes not easy. Sometimes we must do the right thing in the face of enormous pressure to remain silent. The witnesses felt this pressure. The House felt this pressure. And the Senate is feeling this pressure. It's unfair and it's wrong. But despite the forces that seek to intimidate the Senate, you have taken the first steps toward the truth by giving the people who did the right thing a chance to testify. Despite the attacks that they know will continue to come, the witnesses will do the right thing once more. And they will take this witness stand, and they will provide the clarity that the Senate needs.
So we are going to get live testimony in the Senate? That's going to be cool.
To find out what was really happening.
Live testimony in impeachment proceeding? Okay.
As chair,
I mean, fine.
I give this statement with the support of and on behalf of the Board of Managers.
I mean, that kind of makes it worthwhile just by its own self. We're going to get live testimony in this
You all
MFR.
provided us with an hour to make an opening statement. But we prefer to yield back the rest of that time to the most important folks that will show up in this room, the witnesses. The same witnesses that Mr. Paxton has been so desperate to discredit and intimidate and to silence.
Mic drop it, baby. Mic drop.
We are honored to be able to give them their day in this honored and rare court where we simply seek justice.
I like this guy. I would follow this guy. I would follow his mustache, man. I like this guy. Does he need a law clerk or something?
Make an opening statement.
This is good shit, man.
We do, Your Honor. I think we have.
All right, what you got for us, Mr. Paxton?
Break. Is that what was in the rules?
You're up right now.
May it please the court. I stand in this hallowed chamber in this historic proceeding on behalf of the duly elected Attorney General of the state of Texas. The prosecution and the press, and I'm sure here, will tell a whopping story.
Ooh.
It's a tale full of sound and fury. It signifies nothing.
Okay, all right.
You may wonder why I say that. Because when we are done, I believe that no matter your party affiliation, and no matter where you stand now, you will conclude what I have concluded, that there is nothing to this.
Okay, all right.
Ken Paxton gave nothing of significance to Nate Paul. Nate Paul received nothing of significance from Ken Paxton. This whole case is a whole lot of nothing. I make my living trying cases to Texas juries. Cases are supposed to be decided only upon the evidence. But I do wonder, are we really going to get a fair trial here? Have you already decided based on what is politically expedient or what's best for you personally?
Ooh.
Or is it even possible to get a fair hearing? Especially after this case has been tried in the press, Ken Paxton has been convicted in the press based on ignorance, innuendo, and outright lies. So the question is, will you decide based only on the evidence?
I kind of like this guy
Because
too.
that's your oath. That's what you swore to do, no matter the consequences. And I urge you to do your duty.
He's a good trial lawyer.
Fear.
I like him. He's a good trial lawyer.
They say this is the impeachment of a lifetime. But is it? Because depending on what you do here, maybe it will become commonplace.
Ooh.
What happens here will have consequences no matter how it turns out. Let's be clear. If this misguided effort is successful, which I feel confident it will not be, the precedent it would set would be perilous for any elected official in the state of Texas. What is being attempted here hasn't happened in our state in 100 years. And unlike other efforts of the past like this one, this scheme was rushed, it was secretive, it was poorly planned, and was wholly unsupported by evidence. Indeed, despite the social media frenzy, the misinformed commentators, the reporters with an agenda, at the end of this, you will come to know what I know, that despite all of us being told that the evidence in this matter is 10 times worse than the public knows, it is instead 100 times less. There is nothing here to support impeachment. Nothing.
Like that parallelism. It's
Now,
a nice little rhetorical trick, right? It's supposed to be 10 times worse, but you'll find it to be 100 times less.
Disadvantage.
Floating opposites.
That gag order prevented us from rebutting the false narrative created by a frenzied press. The gag order, of course, didn't stop those media members with agendas or those media outlets aligned with the House managers, and they were calling for Ken Paxton's head. We've heard in the media about burner phones. There are no burner phones, but we couldn't respond. We've heard about secret email addresses. It's so secret that every person on Ken Paxton's staff used the same type of email address because they were traveling to China. There's no secret email address, but we couldn't respond. We've heard about Uber rides for Ken Paxton in Vegas, Chicago, or to even nightclubs. Those are manufactured lies, but we couldn't respond. We've even heard from the press about cakes from H-E-B, stolen pens, pilfered sport coats, outright foolishness, but we couldn't respond. We heard about house renovations supposedly paid for by the manipulating boogeyman, Nate Paul. That never happened. Ken Paxton and Angela Paxton paid for their house renovations, and I'm going to show that absolutely 100%. They know it, but yet they still stood up here and repeated that lie. Let's talk a little bit about some background. In 2015, Ken Paxton ran against the anointed candidate for Attorney General Dan Branch. Branch represented Highland Park and the political elites. Dan Branch was the establishment candidate. Ken Paxton beat him soundly. Almost immediately after that win, Ken Paxton was on the receiving end of a clearly political indictment at the hands of rivals within his own party. That saga continues to this day with a pair of unelected special prosecutors nudging it forward year after year with the expectation and hope that someday they will get paid.
Okay.
Nevertheless, despite being indicted and despite a very public lawsuit that makes the exact same allegations that are being made here, Ken Paxton easily won his last primary, as he has in every election. In fact, Ken Paxton thumped the establishment candidate, who this last time happened to be a Bush. And it wasn't even close. Ken Paxton won 68% to 32% in the primary. Now think about that. General Paxton trounced the establishment candidate, a member of the Bush dynasty, and beat him badly. And incidentally, as an aside, did you realize that the day before the vote for this impeachment was had, that same Bush applied to renew his law license? Let's put this proceeding in context.
I'm not sure what that has to do with anything, but okay.
Almost 30 million people live in the state of Texas. Texans chose at the voting booth who they wanted to be their attorney general, despite the same baseless allegations that are being made here. But because of what this House has done, only 30 people out of almost 30 million will decide whether Ken Paxton is allowed to serve in the office he was voted into. Okay. That's not how it's supposed to work. That's not democratic. What could be less democratic than 30 people deciding who serves as the Attorney General of Texas instead of the 4.2 million people who voted to put him there? Every election season we hear, your vote is your voice. It's important to go vote to be a good member of society. We hear about the sanctity of the right to vote. We hear that people fought and died for the right to vote. We hear every vote should count. Yet to get here, Texas House took away the votes of over 4 million Texans who voted for Ken Paxton, and they did it in only a 4-hour hearing. There is a right way for Texas voters to remove someone from office. It's called vote against them. Who the people want, who the people have voted for, should matter. Let me give you some names. George P. Bush, Eva Guzman, Louis Gohmert, Dan Branch, Barry Smitherman, Joe Jaworski, Rochelle Garza, Justin Nelson. Those are just some of the people that Texans decided they did not want to be their attorney general. The people chose General Paxton. Do their votes matter? People are watching. The will of those Texans should not be subverted. And people of Texas, let me say this. I am very happy that these proceedings are being live streamed. I think it is good that Texas voters can hear every bit of evidence or the complete lack of evidence that supports this from both sides. I'm sure that the more than 4.2 million people who voted for Ken Paxton will want to hear why. Will want to hear why 30 people are deciding his fate. And through all of this, we must not forget, Ken Paxton, for the last 8 years, has operated the most aggressive, effective litigation apparatus of any attorney general's office in the country. According to the pundits, Ken Paxton was never supposed to be serving in statewide office. But Ken Paxton is very much serving. Look at his record. Under his leadership, the AG's office has won major cases for Texas on immigration, the lives of the unborn, religious freedom, and the continuous overreach by the federal government on our everyday lives. Under his direction, the AG's office has sued the Obama and Biden administrations more than any other AG office in the country. Even CNN has called Texas a legal graveyard for Biden's policies. And under his watch, and with his personal involvement, the Attorney General's office has recovered billions of dollars for Texas taxpayers, including $3 billion against Big Pharma as a result of the opioid crisis. It has been said, but I think it's worth repeating. Ken Paxton is the best attorney general in the country, period. All of this, of course, begs the most pressing question. If Ken Paxton is so good at his job and routinely defeats his political opponents at the ballot box, then what the devil are we doing here? We know this entire process took less than 2 months with fewer than 15 witnesses, none of which were ever put under oath. Shouldn't this investigation, if done right, have taken a whole lot longer? After all, this historic procedure took an entire year the last time it was used, with sworn testimony taken by the committee, in open hearings, giving the respondent an opportunity to be heard, to confront his accusers. So why was it so short this time? Why did it happen when it did? What was the rush? Because if they had taken their time and done it right, we wouldn't be here. We wouldn't hear about burner phones. We wouldn't hear about house renovations. We wouldn't hear about secret Uber rides. We wouldn't hear any of that foolishness because they would have delved into it and saw that it was all false. So why? I'll tell you why. On May 19th, 2023, Speaker Dade Phelan was so drunk while running House business, he could barely even hold the gavel. And that drunkenness was on video and was on the internet for the entire world to see. I'm sure you've seen the video as well. 4 days later, on May 23rd, Ken Paxton issued a statement and called for Dade Phelan to resign. In response, the committee hurriedly met the very next day, conducted a 4-hour hearing, and recommended impeachment the day after that.
Political vendetta, I like it.
Because of the rush, the House didn't bother to vet this foolishness, and now they've put it right in your lap for you to do the work that they failed to do. This impeachment was the perfect marriage of a group of representatives fueled by a powerful lobbyist and led by a drunken speaker seeking political vengeance. It was also a result of a group of uninformed civil litigants and their attorneys who are motivated by money. The House's General Investigating Committee proceeded in a rush, in secret, so secret, in fact, that the only people who could have testified and brought actual evidence and exonerated Ken Paxton were not even called. I hope you will look at the evidence. I hope you'll really look at the evidence. I have faith in this body that you will actually see the evidence and make an informed decision. I want to focus just on a few of the impeachment articles. There's so many of them, I wouldn't have time to go through every one. But I think one that you might be interested in is Article 10. That's the article where the House managers have argued that Ken Paxton's house renovations were paid for by Nate Paul. And you've heard that lie repeated over and over and over again in the press, and it's false. The House managers adopted this lie about a non-existent bribe and repeated it with no evidence, nothing. The news media endlessly amplified this lie without ever documenting it. And then it's been repeated over and over, and even repeated by my colleague today. Hear this, press corps. Ken Paxton and Angela Paxton paid for their house renovations. Period. You will see in this case a STEAM team estimate. The Paxton's house in Terrytown had some water damage. STEAM team came out to correct the water damage. We're going to show you those documents where USAA claim was made to pay for that. You will see that the Paxtons had fits with the insurance company, just like all of us have at one time or another, trying to get that claim paid. You will see that Angela Paxton specifically was involved in talking through some of the repairs they were going to do as part of that process. They were going to do some upgrades, and you'll see mind-numbing pictures of Angela and Ken Paxton at Home Depot, at Lowe's, pricing stoves, pricing countertops, trying to get the best buy, and ultimately deciding that despite what you hear about granite, with all due respect, Senator Paxton, their countertops are just old ratty tile. And they didn't get a new stove. And they didn't get to change out their cabinets. But that's not what you've heard in the press. I'm going to show you the USAA docs. I'm going to show you that on September 16th of 2020, USAA made its final determination of what they would pay. They paid for Steam Clean, the original contractor, and the second contractor was Cupertino Builders. And you've heard, that's a foul. Busby in the press conference, he showed Cupertino Builders' invoice. That company didn't exist. Well, guess what? It did. It absolutely did. I'm going to show you the documents, and you're going to see that this article is false, just like every other one. You're going to see the USAA determination. You're going to see that USAA knew that they had another contractor. You're going to see a text from the trustee back and forth between Ken Paxton, where Ken Paxton says, I have this invoice, I have to pay it. You're going to see all that, and you're going to see the wire come from the Paxton's bank account and go into Cupertino Builders' bank account. You're going to see the front side of the transaction and the back side of the transaction, and you're going to conclude, like I've concluded, like everybody has to conclude, that these folks were pinching pennies. They were trying to update and renovate their house, and there were a lot of things they just couldn't afford. I'm going to show you pictures ad nauseum of their house, and you will conclude what I've concluded is the Paxtons have been defamed over and over in the press and by the House. Now, the second so-called bribe, Nate Paul, the boogeyman Nate Paul gave Ken Paxton $25,000. Oh, goodness gracious. Do you know when he gave that money? October 2018. Years before any of these allegations ever existed. Years before any of the acts allegedly that occurred ever occurred. Think about their theory. Their theory is Nate Paul in October of 2018 was thinking, he was so manipulative and so smart that he knew at sometime years in the future, he may be needing something from Ken Paxton. Here's the problem with that. He gave money to people in this very chamber as well. Ken Paxton wasn't the only recipient of a campaign donation, but let's focus on campaign donations. Incidentally, in 2018, Ken Paxton raised millions upon millions of dollars, a $25,000 donation, although it sounds like a lot of money. Ken Paxton is a great fundraiser. He raises a lot of money, and that donation ain't even a blip on the radar screen. But let's think about that. Campaign donations can't be bribes. They are not bribes. Do any of us believe that a campaign donation in here is a bribe? You know how often I get calls for campaign donations? A lot. Are those bribes? No. If campaign donations were bribes, everybody in this town would be impeached. Just line up. Once we finish Ken Paxton, we'll start impeaching everybody else. I want to shift our focus from the time I have and address what could be the elephant in the room. There's been some salacious allegations made about Ken Paxton. The argument is that Nate Paul provided a job for a woman named Laura Olson. It doesn't hold any water. Laura Olson applied for a job. Laura Olson got a job. You're going to see the employment contract. You're going to see what her salary was. You're going to see her pay stubs. You're going to hear about the work that she did. And you're also going to hear that she continues to do that work today. Today. That was not a bribe. That was a job sought out and received, and she's doing real work today. You'll see the pay stubs and you'll see the employment application. Now, you've heard so much. My colleague talked about how Ken Paxton turned over the keys to the AG's office to Nate Paul. Remember hearing that? Totally false. One of the things you're going to see in this case is that Ken Paxton got nothing from Nate Paul, and Nate Paul got nothing from Ken Paxton. Let's look at what Nate Paul got from the AG's office. Nate Paul believed that the feds had targeted him. He believed that the feds had violated his civil rights. He believed that an affidavit, a warrant for the search of his home and businesses had been altered. He believed it, still believes it today. He didn't know where to go. He went to Ken Paxton. Ken Paxton sent him to the Travis County District Attorney's office, who then turned around and referred it back because of conflicts. There were conflicts. But what did Nate Paul get from that? No bankruptcies were averted. No foreclosures were stopped. No FBI agents were indicted. No FBI agents had to respond to any subpoena. Nothing. Nate Paul got nothing. If that was an attempted bribe, That was the least effective one in the history of the United States. You're going to see Nate Paul got nothing. In fact, you will also see email after email after email of Nate Paul and his lawyers sending letters to the AG's office, madder than a hornet's nest. You're not doing your job. You're not doing your job. You're not doing what you're supposed to do. We're going to sue the AG's office. Does that sound like somebody who has the keys to the AG's office? It sounds like somebody who might be a little entitled and thinks that public officials should jump when he says jump, maybe jump and hope he jumps high enough. But one thing is clear, Nate Paul got nothing, and he was very unhappy about it. He did not think the AG's office was doing its job, and he sent email after email, letter after letter, culminating in a letter where he threatened a lawsuit against the AG's office. You never saw those emails, did you?
Good
You
use
never
of
saw those
pausing.
letters, did you? You never even heard about them. The press knows about them. They didn't report that, did they? This idea that the AG's office harmed the Mitty Foundation. Do you know who the Mitty Foundation is? Do you know their history? Do you know who the first AG was that had issue with the Mitty Foundation? Greg Abbott. Greg Abbott. Greg Abbott sued the Mitty Foundation for all kinds of foolishness. They had one person indicted. They had another person who allegedly beat their wife and child. There was like a lot of turnover. And in this particular instance, you will see why the AG's office decided to intervene. There's a memo that lays out the tortured history of the Mitty Foundation and the decision-making matrix. And every single person in the chain of command signed off, including the so-called whistleblowers, to intervene in the Mitty Foundation case. Not to protect charity. See, this is the misconception. The AG's office is not there to protect charities, as has been alleged. The AG's office is there to protect the public. Interest in charity. In other words, those are donated funds, and the charity better take care of its P's and Q's. And the Mitty Foundation was not. And Nate Paul was so mad that the AG's office wasn't doing more. The AG's office intervened. The intervention lasted 3 months, and the AG's office dropped the case once they saw what was going on. And remember this, you'll see the memo where not only did the entire chain of command decide to intervene in the Mitty Foundation litigation, but also decided to open an investigation of the Mitty Foundation. Have you heard that in the press? This is what we're up against. We are trying a case not here in front of you, honorable members. We're trying a case where we're getting prosecuted in the press. And so here we are, the baseless allegations thrown at us, shotgun approach, throw it against the wall, see what will stick, and make them respond. That's what this is. That's what this is, and that's what it has been. There's a reason my colleague did not go through any facts to support this, because there are no facts to support this. And let's also talk briefly about this so-called midnight opinion. Again, utter foolishness. Did you know on the very day that the informal guidance was issued, they issued another one the very same time frame, like the very same day? You want to know how many foreclosures were stopped by the informal guidance? 0. They didn't report that either, did they? And you didn't hear that either, did you? Many of these articles, I would respectfully suggest, if you look at what's alleged and you look at the evidence, you'll dismiss it out of hand. This is a good one. They claim that this was an AG's opinion, this so-called midnight opinion. On the very face of the document, it says this is informal guidance. It's not a 402 legal opinion. That should have been the reason that should have been dismissed. But we will show that to you. We will prove that to you, and that article should be disposed of in short work. Now, finally, let me talk about these ex-employees. One of the facts that I find to be the most egregious with regard to these ex-employees is that they made assumptions about their boss, but they did not raise those assumptions with their boss. Many of the issues in this particular case, most of those so-called whistleblowers participated in and signed off on. You know what the genesis of all this is? Remember I talked about the referral to from the district attorney's office to the AG's office? They were unaware that the district attorney's office had done a second referral that did not go through the AG's office. It went directly to this young man, Brandon Kamick. And so when they saw that Brandon Kamick had gotten subpoenas that went to some financial institutions, their heads almost exploded. And rather than asking the questions, calling the DA's office, finding out what was going on, they just assumed that this young man, this young lawyer who was being paid $300 an hour, because that was the rate, and that's why we got somebody like Brandon Kamick. But they assumed that he was off doing something untoward. And they never asked the questions, why would you be subpoenaing a financial institution? Because it was a second referral from the DA's office, a second referral that gave him the authority to investigate bid rigging. We all know there was bid rigging going on in Austin. That was what the DA referred to the AG's office to investigate, not prosecute, investigate. They assumed the worst. And instead of asking their boss, you know what they did instead? They sent a letter to the FBI saying that Brandon Kamick had appeared in front of a grand jury. He never appeared in front of any grand jury. The subpoenas were prepared by the DA's office. All he did was DocuSign them. And they sent that letter to the FBI. They came and met with some of the governor's staff. They came and may have met with some of you even, instead of meeting with their boss that they claimed they were loyal to. And you want to know what's most egregious? They sent letters and they took Ken Paxton's name off the letterhead. Now you think about that for a minute. Oh, these people were retaliated against and fired. Ken Paxton was trying to hide something. Let me just ask you point blank. If one of your staff, your chief of staff, decided that he disagreed or she disagreed with one of your actions, and decided when you were out of the office in Ohio trying to put together the Google case with a bunch of other AGs to recover monies for the state of Texas while you're gone, they get together, they send everybody home, and 8 of them meet, and they take Ken Paxton's name off the letterhead and start sending correspondence without his name. Imagine if your chief of staff did that, you would fire them on the spot. If you're a subordinate and you disagree with your boss's course of action, you raise it with her or him, and if there's still a disagreement, you resign. That's how it works. What you don't do is try to hijack the office, wage a coup, or all the other things that did. Sabotage grants. You know, they tried to sabotage the grants that the AG's office would receive. Millions of dollars of grants. They tried to sabotage the office. You're going to hear a much different story when you hear the evidence. A much different story. And let me finish with this. There's a young man named Drew Wicker. He's been all over the news. You remember who I'm talking about? I think my colleague made it clear, and we all know that you guys read. I mean, obviously you pay attention to what's going on. That's part of your job. There's a young man named Drew Wicker, a good young man. He was interviewed by the House investigators. I want you to watch and listen to that interview, because they asked him, did you ever deliver anything to Nate Paul? No, never happened. They came back 5 minutes later. When you delivered things to Nate Paul, how many things did you deliver? This is how they did this young man, who feels like he's in between a rock and a hard place. He's friends with some of the people that quit or were fired, And he still says that Angela and Ken Paxton are like family to him. And they squeezed him. And they squeezed him. He's the one, you may recall, that said, I was there in the kitchen, and Angela had expressed that she wanted granite countertops, and Ken Paxton was there with me, and Kevin Wood, the contractor, says, let me check with Nate. And then we heard about $20,000 granite countertops. I don't know where those are, Senator Paxton. I don't know where those are. What you'll see instead is I have the samples that when they went to Home Depot and Lowe's, and they sampled and they priced it and they decided they couldn't afford it. Nate Paul had nothing whatever to do with it, and Drew Wicker knows that is true as well. We look forward to putting on this case, and we hope you'll listen to all the evidence. We hope that you'll make a decision not based on political expediency, but based on the evidence you're going to hear. And remember, the burden of proof. It's not we throw out allegations and you say, oh, that sounds sexy, I'm voting for impeachment. They have to prove their case by the numbers beyond a reasonable doubt. They won't be able to do that. And on that point, I'm going to turn it over to my colleague for my time remaining, Dan Cogdell, who has some points he'd like to make. Dan?
Okay. A little heavy on rhetoric. He definitely had some points in there that were well done. But a little buried in the rhetoric. A little bit of reorganization, I think, would have helped. But he does have a good rhetorical style.
But
it's not bad. It's not boring. It's energizing.
Wonderful.
And he definitely refers to things you're going to hear. I don't know. Could have.
Counselor, you have to stay at the mic.
Little tweak.
I'll do my best. Good afternoon. My name is Bo. Getting off to a great start. My name is Dan Cogdell. Anthony Oso and I are two of the lawyers that are helping Ken Paxton. You know, when you get ready for a case like this, there's some things that you know, and there's some things that you don't know. Well, in this case, when I was preparing, I knew I was going to know most of the lawyers. I know my opposing counsel, known them most of my life. They're friends. I'm not going to say anything negative about them. It should give you some pause, though, because if they're friends with me, you know their judgment is a little bit askew. That having been said, I know some of the witnesses. I know Mr. Penley. I know Mr. Maxwell. Most of these people are good people. I have no problem with their character, generally speaking. I have a big problem with some of the things that they did. I don't mind sharing with you that my wife is going through a significant medical issue.
What?
And wasn't the best time for me to come here. But she said, no, you go. This is bigger than me. This is bigger than you. And this is bigger than Ken Paxton. No offense, Ken. She's not your biggest fan. But what she meant by that is we are living on the wet end of democracy right now. Is it up to the voters, or is it up to politicians to see who stays in office?
The wet end of democracy? Is that a phrase?
Your decision is much bigger than Ken Paxton.
Raise your hand in chat if you've ever heard the phrase wet end of democracy. Is that a thing?
In this state. I appreciate Mr. Murr's comments. I also appreciate the focus on the bigger picture and what's happening in here. One of the things that's intimidating, even I've been doing this for a long time, 42 years. Sometimes I don't recognize that dude in the mirror when I walk in the mornings. But I wondered to myself, how do I begin a case like this? This is a case of enormous consequence.
Southern saying? I grew up in the South and I've never heard it, so I guess I'm paying attention to the wrong people. Damn.
Things, right? As a side note, this may be one moment I get to relish because I'm not automatically the biggest ego of the lawyers involved. Not automatically. I have some competition. The significance of this case is titanic, as I mentioned, And I wondered, what am I going to do? What am I going to say? Oh my God, I need the hook.
Idaho?
I need the pop.
All right.
And it occurred to me, I don't need that. It occurred to me that I have the truth. It occurred to me that the reason we're here...
I grew up in the South. I'm just saying. I grew up in the South, and I've never heard it.
This is the very room...
So I don't know if I'm in the wrong part of the South or what,
has
but...
been sworn in again.
Apparently I missed out on...
This is the very room...
Apparently I missed out on wet end.
...where one of his daughters got married. How do we go from that to here? I'll tell you how. Because people assumed things that weren't true. They assumed that Paxton was involved in an illegal relationship with Nate Paul. They assumed that Paxton's actions were intended to get the records to Nate Paul. They assumed that Paxton gave the DPS records to Nate Paul. They assumed that Paxton hired...
Also, does that imply there's a dry end to democracy?
All of those things...
And the dry end is where we want to be?
Even Einstein said assumptions are made and most assumptions are wrong. A man much lesser, perhaps, than Einstein, but it's important to me, my dad, he told me when I was a young kid, you know, son, you can't spell assume without making an ass out of you and me.
Wow.
And he's right. And that's exactly what happened in this case.
Wow.
The reality is, this is not a trial where you can assume anything. This is a trial that requires proof beyond a reasonable doubt. Spoiler alert, it's the same amount of proof that's required in a death penalty case. I'm a visual learner. I like to see things to help me learn. So I'm going to offer these next slides to you. They're not the law, but they're an explanation. We deal with different standards. A lot of you are lawyers. A lot of you know these things, but a lot of you have never dealt with proof beyond a reasonable doubt.
When did we get discount Billy Graham into this?
Probable cause. If probable cause were a house, probable cause might look like that. Probable cause is the same standard by which the House had to, quote, indict or return the articles of impeachment. That is the quantum of proof that was required. Preponderance of the evidence. That is the standard.
Are you seriously explaining? Are you seriously explaining different levels of proof to the Texas Senate?
Any little bit more.
Who the vast majority of whom I'm sure are lawyers, and you're explaining this?
Quantum of proof.
Holy shit, dude!
Required in a.
You want to patronize a little bit? Holy God! Let me explain to the Texas Senate about. Now I know you guys are just a simple bunch of politicians and never heard of this stuff. So let me explain the basics about standards of proof. Holy God!
Mr. DeGuerin's house. It would look like a big house. Sorry, Dick. My point is a pretty simple one. There is a huge difference between the quantum of proof that the House based its decision on and what you are required by law to base your decision on. It's night and day. I'm going to go through the articles quickly. Judge, how much time do I have left?
21 minutes.
Oh, good.
21 minutes.
I may give a couple of those back. We'll see. Here's the allegation that Paxton directed employees at his office to act contrary to law by refusing to render a proper decision.
No, Beret says, to be fair, we've seen lawyers on your channel who don't know standards of proof either. That's sadly true.
Records held by the DPS.
That is disturbingly correct.
By issuing a decision involving another public information request, which is a mouthful.
That is too correct.
Was contrary to law and applicable legal precedent. That's the allegation. Here are the facts. Fact number one is that Paxton is the Attorney General.
No, he's not, technically.
The Attorney General can decide.
Technically, he's not the Attorney General, as long as we're talking about facts.
These inquiries.
And best correct is, no, he's not, technically.
Fact number two, Paxton did not order the release of the records. That's kind of been lost in the wash here. There's all these suggestions that Paxton ordered the release of the records that ostensibly were favorable to Nate Paul. No, he didn't. He did not order the release of those records, period, full stop. What he did was had his office take no position on whether or not the records should be released. That's a different color of horse. Fact number 4, that no records were released to Nate Paul as a result of the actions of Ken Paxton. Let me repeat that. Nate Paul got not a single record based upon the action of Ken Paxton. Fact 5, there were other records that were released to Nate Paul and his lawyers, but they had nothing to do with any action by Ken Paxton. You follow me? Other records were released, but not at Paxton's direction, suggestion, interference, what have you. Misuse of official information. The allegation, specifically Paxton improperly obtained access to information held by his office that had not been properly disclosed for the purpose of providing that information to the benefit of Nate Paul. That's the allegation. The facts are a little different. Fact number 1, Paxton did not illegally access any records. Let me repeat that. Despite what the allegation is, he never accessed any record illegally. It didn't happen.
Did he access
As
the
Attorney
records
General,
legally?
Paxton had every right legally to access those records. Fact 3, there's no evidence that Paxton copied those records. I'm kind of getting into the weeds with you here, but bear with me. There's a fellow named Vassar that you'll hear about. He had the file and is responsible for maintaining that file. He gave those files to Mr. Wicker.
I don't like this guy as much.
Talk to you about. Mr. Wicker is an aide that works with Ken. Wicker says he was never asked to copy the file. I think the evidence is going to be pretty overwhelmingly that Ken Paxton may be more technologically challenged than me. So if anybody was going to copy those files, it wouldn't be Ken Paxton. I'm not even sure he had the code to the copy machine. Paxton
Really?
Gives
So
the file
let me get this straight. Let me just make sure I
Wicker
understand this correctly.
gives it back to
Your defense is Ken Paxton,
and there's no
the Attorney
evidence
General of
that Paxton
Texas,
gave those
doesn't know how to use a copy
to Mr.
machine.
Paul. There's this big kerfuffle. And look, you're going to hear from a fellow by the name of Dave Maxwell.
Ken Paxton,
Dave is
the
6'6",
Attorney General of Texas,
without the Stetson,
doesn't know how to use a copy
Paxton
machine,
asked
is
him
what
to
you're
send you
going
a
with?
Texas Ranger, and by God, they send you Dave Maxwell.
Okay.
I'm a fan of Dave Maxwell, generally speaking. But Dave Maxwell did some things and said some things that weren't true. While he was being interviewed by the House, he said, and I quote, Ken Paxton gave the file to Drew Wicker and he delivered it to Nate Paxton in an alley in the dark of the night. That's absolutely false. Maybe Dave was just comfortable in his own skin and thought he could stretch out his credibility. It's either a mistake or a lie. I don't care. Whatever it was wrong. That never happened. Months later, Wicker gives an envelope to Nate Paul, an envelope, but there's no evidence that that envelope contained these celebrated documents, and I suggest to you that these documents would have been several inches thick, not 2 or 3 pages, and it was, I'll skip past that. But at the time, or really after the time, when the Board of Managers is claiming that Nate Paul
I'm falling asleep.
had these documents, his lawyers are still suing in court to get the documents. That makes no sense. Why would his lawyers still be pursuing civil remedies, which they're entitled to do, to get these documents if he already had the documents and if he'd gotten those documents from Ken Paxton? That is dumber than a bucket of hair. It makes no sense. They're just wrong. Maybe they had good
Dumber than a
intentions.
bucket of hair.
Maybe this was their belief.
That
at the
what I've
moment,
heard before.
but they're
That's been a
wrong.
long time, though.
5th allegation, disregard of official duty, the engagement of Brandon Kamek. It is, while holding office as Attorney General, Ken Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. We'll get into that. And Paxton engaged Brandon Kamek, a licensed attorney, to conduct an investigation into a baseless complaint. That's the allegation. During which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul, whatever. Here are the facts. Fact number one is Paxton has every legal right to hire Brandon Kamek. We're going to get into the why, but he's got that right under the government code. You're going to hear a bunch of kerfuffle about one of my favorite terms, the EAM, the Executive Action Memorandum. Sorry, but only in state government could we come up with a phrase like the Executive Action Memorandum. What it really is, it's policy. It's not the law. It's an internal policy within the Attorney General's office. It is not the law. Fact two, Kamek was not an attorney pro tem. Maybe that's a distinction without a difference, but that's what they've alleged. And you would think that these lawyers and
I thought EAM stood for Emergency Action Message.
Lawyers, most of which, or many of which, are ex-DAs. An attorney pro tem.
Yeah, I thought it stood for Emergency Action Message.
When the entire office has been disqualified.
For nuclear
this
subs.
Has nothing to do with that. Brandon Kamek.
We're doing nukes now?
As the documents say, as an outside counsel. But they've alleged in their complaint he was an attorney pro tem. He was not. Fact three, a baseless complaint. Here's the funny thing about being a baseless complaint. They forgot to tell Brandon Kamek about that. And we've got a lot of people that have been hurt by these allegations and the investigations, and I guess it depends on your viewfinder on whose ox is getting gored, and whether you like Brandon Kamek or not. He got absolutely skewered in the press. He was vilified by the press. He was just taken to the woodshed. He was beat like a rented mule by the press. And all that young man was trying to do was doing an investigation that the people who worked for Ken Paxton wouldn't do. And guess what? No one bothered to tell Mr. Kamek that it's a baseless investigation. In fact, he was told by Ken Paxton the same thing that Mark Penley was told by Ken Paxton, who parenthetically, I know and I like, but he didn't do anything. But more importantly, the direction given to Penley, the direction given to Kamek was the same. Find the truth. Let me repeat that. The direction that Paxton gave him in this corrupt, invasive, corrosive, bribery, kickback, horrible scheme, the direction he gave Mark Penley, who worked for him, was exactly the same direction he gave Brandon Kamek. Find the truth. We're going to impeach a sitting attorney general for giving the direction, find the truth. Not one person, not one piece of evidence will you hear where they say lie, where Ken Paxton told him to lie, cheat, steal, shade, do whatever it takes. That didn't happen. That didn't happen. And yet here we sit with 31 of you, with 15 of us and 15 or more of them. Here we sit when the allegation is it's corrupt, when the truth is, he said, go find the truth, for God's sakes. What are we doing here? Oh yeah, this baseless complaint that Mr. Murr, nice to meet you, sir, that Mr. Murr referred to, it wasn't a baseless complaint. The Travis County DA's office referred it to the AG's office, and ultimately a second one to Brandon Kamek. It may not be the greatest, sexiest complaint ever, but it wasn't baseless. Fact four, no one bothered to tell Brandon Kamek. I think I've got a bit histrionical about that.
A little bit, yes.
And another one of my friends, Johnny Sutton, former United States attorney, worked under W, great lawyer, fine fella. But these same folks, the whistleblowers that are carping so much about Ken Paxton and going outside counsel and doing all these ultra-virus things when hiring another lawyer, they were trying to hire Johnny Sutton, who, last I checked, was an outside lawyer. Now, you got to be asking yourself, why is it that Paxton hired Kamek? Number one, Paxton believed in good faith that there had been misconduct. Number two, he asked his deputies to investigate it. His direction was simple: seek the truth. His staff did little to nothing in terms of an actual investigation. He asked again, nothing really happened. No one seemed to be interested in it at any of it. For 2 months, it just sat there. The one time where Ken Paxton comes to Mark Penley and says, hey man, I'd like you to look at this, he does nothing. He does absolutely nothing. Frustrated, he interviews outside lawyers and decided on Kamek. And again, he gave Kamek the same investigation, or same instruction he gave Mark Penley: find the truth. At no time did Paxton ever seek to impede, impair, obstruct. Here's one of my favorite vignettes that you're going to see. Dave Maxwell, this 6'6" Texas Ranger, iconic figure. He's going to come in and say he was asked to participate in an illegal investigation. Really, Ranger? It's an illegal investigation, and on video, according to you, if your worldview is right, they ask you right there on videotape to participate in an illegal investigation, and you just sat there like a bump on the log. You didn't arrest anybody, you didn't make a note, you didn't cause their agent to file. It was illegal, and you were asked to participate in it, and literally, there you sat. This is our legendary one riot, one ranger in action, doing nothing?
What are you
Really?
talking about?
Paxton just wanted it investigated. Mr. Busby stole a little bit of my thunder on these letterhead issues, but the point might be worth stating again. Who in the world do these people think they are? Honest to God, if your chief of staff came in and scraped your name off the letterhead and sent it out, how much longer do you think they'd be working for you? They wouldn't be, and they shouldn't be. Who in the world gave these people that idea? Who in the world told these people it was going to be okay? I bet you the evidence is no one. They took it upon themselves. They deputized themselves and were some sort of Power Ranger team where they could just do whatever they wanted, scrape Ken Paxton's name off the letterhead, and send
Go Power
these
Rangers
out.
Go Power Rangers.
Mr. Busby also talked to you about Michael Wynn's letter to Paxton, but I think it bears repeating.
Do they have
Under their worldview,
can they assemble into a large
Wynn,
dinosaur structure and take on
Nate Paul,
the monster of the
writes
week?
a letter to Ken Paxton, his supposed co-conspirator, threatens to sue his co-conspirator, threatens to sue the Office of the Attorney General, alleging false statements made by Ken Paxton to damaging Mr. Paul's reputation, claiming inappropriate coordination to undermine the investigation, alleging obstruction to prevent the Mitty Foundation investigation, literally bringing suit against one of his, what in the real world would be a co-conspirator. What's next? A hired hitman suing for breach of contract when he doesn't get paid for the kill? Are you kidding me? This makes absolutely no sense. None. And the reason it makes no sense is because there was no illegal relationship between Paxton and Paul. Look, I get it. I understand why there's some eye rolls about Paxton doing things that most of you would think, I don't know about that. I don't know about that. But here's why Paxton was a little different. These claims with Ken Paxton that Nate Paul was making, they resonated with him. I hear you. They very well may not have resonated with you, but I'll suggest to you, luckily, you haven't gone through what Ken Paxton has gone through for the last 8 years. Let me repeat that, 8 years. How do I know 8 years? Because I have been by his side on that Texas state securities fraud case. In that case, Paxton believed he had been the target of a wrongful prosecution. And here's why. Number one, it had been pending for 6 years at that point, back in 2020 when all the fur was hitting the fan.
Counselor, you have 4 minutes left.
Yes, sir, thank you. Number two, the judge that presided over the grand jury.
Excuse me, objection. I believe the court has said all 4 of those counts are out of this trial. He doesn't get to start talking about the merits of it.
I get to talk about his mindset.
My objection is he shouldn't be talking about this at all based on the court's ruling in the past.
I'm talking about his mindset.
We're not allowed to talk about it. How can he get up there in opening and give his version of it?
I'm talking about General Paxton's mindset as to why these claims were resonating with him.
All right. He started talking about a judge. He's talking about the facts. I object.
Sustained. Continue.
Let me put it this way. Ken Paxton was viewing things from a much different viewfinder than you or I might have been viewing those things through. And there's a reason why he was viewing things differently through a different viewfinder than you and I, because of what he had experienced. And it wasn't what you and I have experienced for the last 8 years. Let me get this through so I don't offend Mr. Hardin any further. Sorry, Rusty.
Ooh.
Here's the difference between what the House did and what you have to do. What you cannot do is assume anything. What you must do is look through the viewfinder of beyond a reasonable doubt. Again, that is a much different process than what the House did. Is there proof beyond all reasonable doubt for you to convict Ken Paxton? And I suggest to you, it is crystal clear that there is not evidence beyond a reasonable doubt. I have one simple ask. Do the right thing. I think the senator that led us in prayer asked for the Lord's help on that. Literally, do the right thing. And the right thing is to vote not guilty. Thank y'all for your time.
Okay, that was not particularly helpful or persuasive, but okay.
For the record, House managers, you have 42 minutes and 34 seconds returned to you. And you have 1 minute and 17 seconds returned to you. Managers, before you call your first witness, we need to deal with this motion with Johnny Sutton. Bailiff, will you bring Johnny Sutton forward? Members, we will resolve this motion and we'll take a short break after that.
I don't know what's going on. We'll find out, I guess.
Members, jurors, I'm going to let you take your break now while we're handling this motion. Be back at 10 minutes before the hour of 3, 2:50.
So they're taking a 15-minute break while they're dealing with whatever there is they're dealing with? Okay, fine. Okay, well, that's where we're sitting on that thing, so we'll just camp out here while we're waiting. I don't know what motion they're hearing. So we'll keep it on in the background in case they share with us, but I don't know.
Yeah, so when you can.
All right, so how's everything going out there? For the 500 of you currently watching, by the way, thank you very much for tuning in. For those of you who might not know me, my name is Kurt Mueller, also known as Uncivil Law. I am a licensed attorney in Texas and Virginia, and also before the United States Supreme Court, and I'm happy to be here with you as we tune our attention to the impeachment trial of Ken Paxton. While there are sort of technically rules in a very sort of technical sense, this is a political process, not legal. So it follows processes that might look like court proceedings, and in some senses are court proceedings, I suppose, but it's a political court, not a legal court. So to some degree, the rules are made up. I mean, the Senate made up the rules. They made up the rules that they passed. So they created the rules, and they decided what the rules would be. And so there they are. And of course, they can always suspend the rules by a 2/3 vote. And on then, of course, also, they can also interpret what those rules mean by a majority vote. So, yeah. So anyways, we're in the middle of this ongoing proceeding. I really like I liked Mr. Muir for the House. I found him very persuasive, very charismatic, very helpful. I found that he laid a bunch of stuff out. I liked the first defense lawyer for Mr. Paxton. I thought that he did a good job. I found it a little rhetorically heavy. I thought that overall he did a good job. He laid some pretty strong claims about things he intends to show. And it's like, I'm going to show you a lot of records and show you a lot of things to show you that this is a bunch of crap, basically. And he basically is like, I can prove the negative. It's like, I can prove the opposite of what they're showing. He makes some pretty strong claims. Now, I thought that he sort of buried it in a little bit of rhetorical flourish. I appreciate that he was strong, and I thought that was good, but maybe there was a way to reorganize that and sort of like take out some, by rearranging stuff, because it was like, it was like, at least in my ear, it was sort of like important information, rhetoric, important information, rhetoric, where maybe it would have been better, like, if you had strung together a couple important things together in sort of a little block and did a block of rhetoric and then a block of stuff maybe, but I found it a little bit disjointed, but overall not bad, persuasive. He obviously has a lot of passion and a lot of style. And then this other guy got up and did, I don't know, his Foghorn Leghorn impression or something, and it was less than ideal. But I don't know. I'm prepared to hear the case, right? I don't know. All I know is sort of what I've sort of heard about in the news. So I don't know. I don't know what the truth of what's going on is. I'm very interested in the fact that we're apparently going to have live testimony. That's kind of cool. We're actually going to get people up testifying in person. Like, you don't see that. You haven't seen that in the last couple impeachment trials that they've done in the United States Congress. Nothing prevents it from happening. It's just not something it's not something they do. Right? So if we're going to get some live witnesses actually testifying in person before the Senate, I'm like, that's pretty cool. We're going to see some live testimony. That's fun. How much time do lawyers really have to prepare comments? Quite a lot. And sort of the opening and even potentially their closing. They've had a couple months to work on it. So they've had a fair amount. 100 witnesses were subpoenaed. Well, they're not going to have that many come forward, but it should be interesting to see what they can do. It should be interesting to see what the evidentiary picture looks like. We'll try to assess it as honestly as we can, as we always do. Try to assess what we think is true. But we'll see. I mean, Mr. Muir definitely has his work cut out for him. He has to prove this beyond a reasonable doubt. So he's definitely got his work cut out for him. And then they also raised issues to the timing of the thing and suggested that this whole thing itself is corruption and suggested it was because of political retaliation. It's because the AG went after the Speaker of the House for being drunk. And so the Speaker of the House did this as a political retribution. Okay. How hard is it to give strong opening statement without looking at notes? How much prep work goes into that? It totally depends on the person and sort of what they want to do. If I were going to do it, I'd probably have it memorized cold, or otherwise I'd have like an outline and have the outline memorized and refer to it for the outline. Just make sure I hit all the points I need to. But yeah, it depends sort of on your style. It depends on your style. It's better to memorize it and only to refer to it as needed. You don't really want to read from it, that's for sure. So if you want to glance at it once in a while to make sure that you've hit your outline, then that's fine, but you probably should have done it a couple times by then. When I was memorizing things, I used to just like get up and walk around the hall and just kind of repeat it to myself. Just get up and start repeating. Well, Colbert Murdaugh's lawyers giving a press conference. Now, if it's happening during this, I won't. This gets higher priority. I saw that Murdoch's things came out with allegations. Yeah, I saw that. Pretty interesting stuff. Yeah, there's a pretty big allegation in the Murdaugh stuff. So we will see how it all pans out. Why are they talking about a gag order? Yeah, there was a gag order issued as part of the Senate rules where they prevented the Senate from speaking about the issue publicly. So they imposed a gag order on themselves. It was part of the Senate rules that they passed. So, and it was raised to the state Supreme Court. The state Supreme Court didn't decide not to get involved, which I thought was questionable, but no one asks me. How often does the Texas legislature go into session? Every other year. So they're out of session. They just finished their session this year. So they're out of session. I'm sure the senators are thrilled, to be there. Tell your lawyer I know said hi. I can't do both, obviously. So I'm sorry I'm losing your viewership to lawyer no. But I can't do both. Just waiting. I was just trying to figure out how to clear browser history in Chrome, but it doesn't look like you can do that anymore for some reason. All history. Yeah, I want to clear all history every time I refresh the browser. I want to clear history every time I reload the browser. Yeah, it used to be on automatic setting of Chrome. It doesn't look like there's a setting of Chrome now. Should just be an easy setting for it somewhere, but it doesn't look like there is anymore. That sucks. Alright, I'm going to switch browsers to Firefox. Give me a second. There's nothing happening, so I can switch browsers real fast. Whoa. Use Firefox. Yep. All right, cool. Google reformat settings in Chrome. I think I'm going to uninstall Chrome for a while. Alex, that tells me how to clear the history this time. That's not what I'm trying to do. I'm trying to set it up so it clears history every single time I close the browser. So yes, I can clear all history now, but that's not what I'm trying to do. I'm trying to clear history every time I close the browser. So that's not the task. And my Windows run bar has now completely crashed. Windows Explorer has crashed. That's good news. The feature was removed. That sucks. Yeah, it doesn't make any sense to remove the feature. I'll unpin it from taskbar. Close Chrome. All right. I have this problem where my search bar in Windows just crashes sometimes for no reason. It really sucks. So like I go to try to run something or type something in the search bar and it just completely crashes. So I have some sort of problem with Windows Explorer somewhere. Molivad has a new browser. I'm gonna check that out. Yeah, I was trying to restart Explorer using Task Manager. It's under services somewhere, right? It happens a lot where it crashes. Yeah, they're taking a break. They're having some sort of motion, which I'm not sure what they're dealing on. Nothing's happening at the moment. We're just waiting. Well, I got Windows Explorer up and running. It's just my search bar still crashed. So I have to reset the thing. See if I can find Windows Explorer and Task Manager and restart it, because it's driving me crazy. Windows Explorer. There it is. All right, let's restart the task. Is it working now? Nope. Search still not working. Oh, maybe it's coming back. Oh, there it comes. All right, it's back. All right, so restarting it worked. Yay. All right. So my search bar is back. All right, so where else can we be? Just a kind reminder to the 500 of you or so who are watching, by the way, as we're on a little break. I do appreciate every one of you who is here. If those of you who have the Twitters, if you could retweet the pinned link, it makes a lot of difference, and tell your friends about it. We'll be here the next couple days, at least, dealing with this, so it should be interesting to be sure as we watch this process undergo. So I hope you like this, and I hope you like the coverage that we're doing, and we'll go from there. So I appreciate everyone who's here, and if you could give the little video a like, that'd be great. Someone gave a donation of $10 to say this guy talks like Strother Martin and Cool Hand Luke. New York Renal MD said not much of a defense right now. Thoughts up to now? I like the first guy. Second guy didn't really do it much for me, though. The taskbar search was crashing. David, taskbar search was crashing. Not sure why. K. Newt is member for 40 months. Thank you very much. Economath, $5. Someone here needs to ask the important question of the trial. Where is Kara Coffee, a.k.a. Sergeant at Arms Mommy? Nathan C., member for 8 months. The wet end of democracy was coined by Bill Clinton with Monica. Nice. Bad Weather Biker was the guy who made the Cool Hand Luke comment. Very nice. Thank you very much. I may have a worm or infected taskbar, perhaps. I've got Bitdefender that I have, and also have malware bytes to look for and find viruses and such. But I ran a search. I ran both recently because I've been having this problem, and neither was able to detect anything. So. Yeah, I don't know where the Sergeant at Arms is. I'm not sure where Miss Coffee is in all this. She's a Sergeant at Arms for the House, right? So she isn't here because this is the Senate, right? So yeah, because she's the Sergeant at Arms for the House, and we're in the Senate. So that's why she's not here. It's not her job. So no Miss Coffee for us today. Very sad. Stream Elements isn't running on this computer at all. Stream Elements is a bot that's running on the cloud. So yeah, Stream Elements isn't running on this computer at all. So Firefox has a clear history when Firefox closes setting. Remember search and form history. I can turn that off. Or browsing and download history. Turn that off. Clear history when it closes. Yeah, just clear all the history. Yep, cool. Bee fish. They're still debating amongst themselves or whatever. They were supposed to be back 5 minutes ago, and they're still like caucusing or some shit. I don't know what they're doing. Anytime they want to start back up, we'll be fine, man. I wish I knew how long they'd be gone, so I could cover something else. I should have covered Murdaugh, I guess, while they were on break. But I don't know how much longer they're going to be on break, so I don't want to go back and do it now. Right, we'll watch a little bit of this, I guess, while we're waiting.
Judge Newman, after he was, of course, convicted in the murders of his wife and his son. I mean, what does this change?
Right to be very. It looks like they're.
So I'm going to read a statement. Jim Griffin will have a couple words to say, and then we'll answer questions. Today, Jim Griffin and I filed a petition based on newly discovered evidence with the South Carolina Court of Appeals to stay Alec Murdaugh's appeal while a hearing is held on a motion for a new trial. Concurrently, we've sent a request to the South Carolina U.S. Attorney to open a federal investigation into the violation of Alec Murdaugh's civil rights. The allegations in the petition filed today speak for themselves, but we believe they explain a number of peculiarities in the 6-week trial. We request that SWED stand down on initiating any investigation of these allegations since they are heavily invested in maintaining Alec's convictions. We suggest they wait for the Court of Appeals to rule and receive direction from the trial court. If the Court of Appeals remands the case for an evidentiary hearing, if the Court of Appeals remands the case for an evidentiary hearing, we would also request that those in the media and the public respect the privacy of those in filing. Jim and I want to thank those on our team who stand behind us and have worked tirelessly to ferret out the truth. Alec Murdaugh maintained and still maintains his innocence in the murder of Maggie and Paul and believes the truth will ultimately prevail. Jim?
The right to a jury trial,
Stand over here.
the right to a jury trial is a fundamental principle of our justice system. Jurors must be free from outside influences and must decide the case solely on the evidence presented in the courtroom, subject to the rules of evidence, subject to the rules of the court, and, most importantly, subject to the crucible of cross-examination that's guaranteed by the Sixth Amendment to the Constitution, and that is the right to confront witnesses. When jurors receive private communications outside the confines of a public courtroom, the Sixth Amendment is violated and numerous other constitutional rights are violated. And that's not Jim Griffin on the law, that is the law of the land. And I want to quote from a decision from the South Carolina Court of Appeals, which is behind me, and states this: where there is a private communication of a court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. What we had filed today, supported by sworn testimony of jurors, is that the clerk of court had improper private communications with the jurors, and the subject matter of those communications was the credibility of the defense that the Murdaugh legal defense team put up, and it was the believability of the defendant's own testimony. Now, there's been a lot of talked about whether Alec should have taken the stand. I can assure you, when we considered what factors and what we should and should not do and considered whether he should take the stand, we never considered the likelihood, as reported to us by the jurors, that the clerk of court would go in to the sanctity of the jury room before he testified and tell the jurors, don't be fooled by his testimony. And no reason to believe it is not. There's no choice but the courts to grant a new trial.
Thank you. Any questions? No? Okay.
When the fourth person was pulled away at Moselle, did you guys see that, or did you find out after the fact?
Well, I think we observed it. We did. No, I was there.
Oh,
Yeah. I was there. I watched it. But, I mean, look, we were not looking to impute any nefarious conduct. But clearly what the jurors reported to us, that they were off talking, the forelady and the clerk. I saw them together, but, I wasn't watching. I believe, look, I've been doing this almost 50 years. The bedrock of any trial, and I've done hundreds of them, is that the clerk of court is the person that makes sure the jury gets their food. If they're put up for the night, someplace to stay, their travel accommodations are met. They're not someone that ever should talk to them about the case. I've never had it happen. Again, I've been doing this for a very long time. Never heard of it happening until this case.
And one thing we want everyone to understand, that the clerk of court is an elected official by the people, not appointed by the judge, not appointed by the judiciary. It's a public official who's elected and is an independent state actor. And so what we're complaining about in the motion that we filed today is the conduct of an elected official, not conduct by Judge Newman or anybody in the unified court system.
And I think it's important also to understand that she is a state actor, and that's why we forwarded today a letter to the U.S. Attorney asking them to open an investigation into the violation of Alec Murdaugh's civil rights by a state actor under color of state law.
I believe you guys had 4 jurors that you had affidavits for in the paperwork you filed. Did they reach out to you, or did you guys reach out to them?
Well, this is an interesting story. Let Jim tell you.
So immediately in the aftermath of the verdict, we had received information that we needed to look into.
What the hell are they doing in Texas? Does anyone have any ideas?
Road, and we met a zone of silence. No jurors would speak to us. And so we were, what I like to call, we were given the Heisman, right? And then when the clerk of court wrote her book, published her book, that zone of silence collapsed. And jurors were upset about that, the ones we talked with, and they were more than willing to come forward and tell us the things that we had sort of heard through a whisper campaign. And so as a result of that, we were able to interview some jurors. Now, there were still a number of jurors who maintained that zone of silence, who had not talked to us. We did try to reach out to most all of them that we could get in touch with, but the information we got, I can tell you, was independent of each juror. The first juror we talked to, we got information about Ms. Hill saying, "Don't be fooled." And then the second juror, independent of the first juror, says the same thing, and the third juror, independent of the other two, say the same thing. And so we're very confident that the information is accurate.
Well,
the expectation timeline. What a ruling will be, how fast we want it.
Ask them. I mean, we don't have any control over that. We just did receive a notice from the Court of Appeals that the Attorney General has 10 days to respond to our motion. Okay? Now, I think what's interesting to me, again, having done this for so long, is that once we had that initial contact with that first juror, we began going around. We had a list and knocking on, literally on Sundays, knocking on jurors' doors, asking them to speak with us. Some of them wouldn't come out. Some of us told us never to come back. But some did, and some talked to us. I'll give you an example. And one of the things we heard was, once the jury went out, even though there were 6 smokers and they were given smoke breaks during the entire trial, once the jury went out, they were told, no more smoke breaks. No, people that want nicotine, you're going to have to get a verdict first. I mean, it's that kind of stuff. Now, that indicates something, and the court would be the one to communicate that. Why? So a bunch of folks told us stuff that appeared to be inconsequential, but in the total context indicated to us that what we've put in this petition.
How's it going in Texas? Are we getting closer to doing something?
Based on sworn testimony from 2 jurors.
Are we getting ready to talk?
And we interviewed a third. My paralegal, Holly Miller, has given you an affidavit, or filed an affidavit of what she told us. A lot of these folks just don't want to get involved. But they're going to be involved if we get a hearing, because each and every one of them will have to testify in an open court before you as to what happened and what didn't happen.
It would appear that
Wait, one at a time. Who?
It would appear that Judge Newman was at least aware
Bailiff,
of
can you bring
some of the allegations that you
back?
talk about in your motion. For example, the Facebook.
All right, looks like something might be happening in Texas. 15 minutes passed. So yeah, apparently there was improper communication, or so the allegation goes, between the clerk of the court and the members of the jury, of the Murdaugh jury, that might have amounted to jury tampering. So yeah, apparently that's the allegation, that they said something like they said the clerk of the court said to the jury, don't be fooled, in relation to Murdaugh's testimony, like, don't be fooled by him, and this should be a quick verdict and stuff like that. Yeah. So we'll go over it at some point. We have the documents.
I just wanted you to be in the room. Councilors and members, the court received a motion to quash a subpoena recently received by Mr. Johnny Sutton, an attorney who represents several potential witnesses in the case. Mr. Sutton filed a motion to quash the subpoena so he may fulfill his legal duties as an attorney representing the clients. After considering the motion and conferring with counsel for both parties, the court believes at this time Mr. Sutton's representation of his clients would not prejudice his testimony, if any, should he later be called a witness. Therefore, his motion to quash is granted. However, Mr. Sutton, the court hereby orders you to make a diligent search for any non-privileged documents, thorough, within the scope of what was subpoenaed by the Attorney General to produce those, if any. And the court will want a response to that search. The court will allow a limited exception to the rule. To the extent necessary to represent your clients, including appearing in the chamber during their testimony. You ask to be excluded from the rule, but that would take a vote by the entire body. Though you may be present in the courtroom for testimony of your clients, you may not share information between clients. You may take your designated seat. Managers, please call your first witness.
Okay.
Here.
So there's a motion to quash, which was granted in part, but I didn't quite understand what the motion to quash was. I think it was with respect to him. I think the motion. I think he was subpoenaed personally, and like, I think the motion to quash was with respect to him in particular, and so like, the motion to quash was granted with respect to him, but he's supposed to conduct a search for any non-privileged records relating to his clients, I think was what just happened. If anyone else had a different understanding of that, let me know. That's what I got out of it. Yeah.
Mr. Material, remind you.
Yeah, lawyer was under subpoena, also representing witnesses. Yeah.
And to help the court reporters clear yes and no's.
So I think the motion was granted with respect to the lawyer. Yeah. So the lawyer was under subpoena. His clients were under subpoena. So they quashed the subpoena, as did the lawyer, but said, give us the search of records.
Thank you. Your Honor, before I start, could I ask if it's permissible to ask the back of the room if they can hear me, since we've all had all these microphone issues here. I want to make sure that if I'm speaking to the microphone like this, can the rear of the room hear me?
Can you hear, senators, jurors? Everyone can hear. Hands up. They hear you clearly.
All right. Thank you very much. State your name, please, sir. Mr. Mateer, how old a man are you?
Hold on. That mic's not on. You have to hit that button right there.
All right, Jeff Mateer. Oh, gosh, sorry, Lieutenant Governor.
We heard you the first and second time. Go ahead.
I am 57.
All right, Mr. Mateer, you're somewhat a victim of my wanting you to try to speak up when we're talking privately, so I think the microphones have taken care of that, okay?
Yes.
And where do you live now?
I live in Rockwall.
I'm going to ask you, in the interest of time, if you would just give us maybe a minute and a half or so, a little bit about your background, where you grew up, family, professional career to where you got.
Yeah, actually grew up in central Pennsylvania, and then I met a girl from Fort Worth, and we were in D.C. together when I was working on the Hill.
You can go down a little bit, I think.
I'll pull back a little bit about
that's
that.
Good. All right.
I was working on the Hill for first Tom DeLay and then Dick Armey. Met my wife. Our relationship was going to continue, it made it clear that our relationship was going to continue in Texas. And so I went to SMU Law School. I graduated from SMU Law School, and then after law school went to Carrington Coleman for the first part of my career.
Carrington Coleman is a Dallas law firm.
It's a large Dallas law firm, about 100 lawyers when I was there. And that was approximately, well, not approximately, it was 1990.
Stop there, and then I'll try to do a question and answer now. When you were at Carrington Coleman, were you also involved in any kind of outside activities at that time?
Yeah, since college, I'd always been involved in Republican politics.
And so I started, did that in college. I was vice president and treasurer of college Republicans. And then even though, anybody that's been an associate at a law firm knows at a large law firm, you don't have a lot of time, especially if you have a family, because I had a young family, but I still stayed involved. And then I began to volunteer on religious liberty cases.
All right. Now, I'm going to ask you, we're going to try to do kind of short answers, and I'll try to jump in. You're aware, as every witness is, that we're working on a time clock here.
Okay. I'll do my best.
That's just my fault. It's my job. Don't you worry about it. Yeah. So were there any particular organizations from the time of college or law school on that you belonged to?
Yeah, I was a member of Christian Little Society starting in law school, and then in law school also became a member of the Federalist Society.
And very briefly, Federalist Society, how would you describe it and what it is?
Federalist Society is predominantly conservative and libertarian lawyers or law students who care about the rule of law and conservative and libertarian policies.
In addition to your political views on legal issues and others, without getting into much detail about it, how would you describe your life and your religion?
Yeah, I would describe myself as an evangelical Christian.
And do you belong to a particular denomination?
I'm a member of a Baptist church.
Okay. Are you a rhino?
Am I a rhino?
Are you a rhino? Do you know? Wait, slow down. You understand the term, do you not?
Republican in name only is the term.
Would you give the jury a benefit of your background, of your political views?
Well, I'm certainly far from right of center. I was nominated by President Trump to be a federal judge.
And your nomination wasn't approved?
My nomination was not successful after there was opposition from, some liberal Republicans and all Democrats.
And the relevance here I want to ask you about, have you heard the suggestion that this impeachment is really the product of rhinos, liberals, Democrats, people that are opposed to the true conservative views? Have you heard that, have you not?
Yeah, I've heard that said, yes.
All right. How would you apply that description to yourself?
That doesn't describe the men and women that I worked with on the 8th floor at the Office of Attorney General.
We're going to get to that in a moment, but as far as you yourself were concerned, was one of the issues that defeated your nomination comments that whether you made or didn't make that had to do with transgender politics?
Yeah, and the comments involved me speaking at a Baptist assembly in which I was alleged to make comments that people on the left perceived to be anti-transgender.
Right. Now, at the
I should say I didn't make the comments that they said that I made, but that was the allegation.
What I'm really after, Mr. Mature, in your life, how would you, when you went to the Attorney General's office, how would you describe what you believed in your politics, the mission of the Attorney General's office, and the profession you had chosen?
Well, look, I've always been, since law school and throughout my career, I believe wholeheartedly in the rule of law. That's something that the Federalist Society, I think, instills in people who are members, but I believe in the rule of law, and I believe in conservative policies and conservative practice.
And have you always been conservative, without going into specific this issue or that issue? Have you viewed yourself very conservative on social? You have to wait me finish. You have to let me finish.
Sorry.
It's okay. It's not often that people like me get a chance to.
Well, I'm in a different.
Wait a second. You have to wait. Not often people like myself get a chance to correct people who've been a chief of staff of some organization. So I'm taking the liberties with it, okay? And I'll stop you if you volunteer. Just let me finish, and I'll try to let you finish. I'm really, in terms of social issues in the political world of today, on a scale of 1 to 10, how would you rank yourself?
10 or 11.
Okay. Now, did you go somewhere else after Carrington Coleman in Dallas?
Yeah, after Carrington Coleman, a group of us who were Carrington Coleman lawyers formed our own law firm called Rosenthal, Reynolds, Mateer, and Schaefer.
Where are you practicing now?
where am I practicing now? First Liberty Institute.
And what is First Liberty Institute?
It's a national religious liberty law firm. It's actually the largest religious liberty law firm in America that's dedicated to defending religious liberty.
And indeed, since at some time recently, have you participated in several Supreme Court cases?
Yeah, since I've been back, I came back in October of 2020. We've had 4 Supreme Court cases, including 3 very important precedent-setting cases.
Well, were all of those cases oriented toward what one might say the religious right?
Yeah, I mean, probably the most infamous or famous one is Coach Joe Kennedy, the praying football coach, who the school district up in Washington fired him because he was kneeling at the 50-yard line after a game. That case took 8 years. We just celebrated him returning to the football field this last Friday.
Now, I want to ask you, why did you, and were you at First Liberty at the time you joined the Attorney General's office?
I was. I started at First Liberty in 2010. I started at the Office of Attorney General in March of 2016.
What was your job when you started with the Attorney General's office?
I was First Assistant Attorney General.
Have you heard of, when did you first meet Ken Paxton?
And I was trying to, I've been thinking about that. I would have met Mr. Paxton sometime prior to probably starting at First Liberty, and I would have been introduced by Kelly Shackelford.
And at the time that you began with the office, what calendar year was it?
What time of year?
What year?
It was March of 2016.
And by that time, how long had you known Mr. Paxton before you began?
I would guess it would have been probably almost 10 years, certainly of him. I didn't know him well, but I would have known of him those 10 years.
Who hired you?
Mr. Paxton.
In what way? Did you meet with him? He call you? How did it happen?
Yeah, he actually approached me a few months before March and had asked me if I would consider coming to Austin. I told him I didn't want to come to Austin. Quite frankly, I had my dream job of being general counsel at First Liberty. Today, I have my dream job.
So is the answer he asked you to join him in Austin?
He did.
Okay.
Well, and I went home and I agree. He asked me to pray about it. And my wife and I did pray about it. And we felt like we were supposed to come down here.
All right. And then, have you ever heard him suggest in public announcements and descriptions and defenses of his charges and so that he hardly knew you guys?
That he what?
That he hardly knew you. If he were to say that he hardly knew you, would that be accurate or inaccurate?
I think
you always have to let me finish.
I'm sorry.
That's okay. Would that be accurate or inaccurate?
It would be inaccurate. I think he knew me very well.
Now, after he hired you, when you went on, I'm going to be wanting to talk to you about the senior staff at the Attorney General's office. Right? And I have a diagram here I want to put up, and I want to try to do this briefly. And that is a diagram of would you put the exhibit up for me, please? Thank you. All right, get the other side. I'll get the other side. Thank you.
Okay.
Now, I'm going to try to go real quickly through this.
Counselor?
But what I'm after here
Counselor?
Excuse me.
Are you offering this as an exhibit?
As a
put into
demonstrative
evidence? To put into evidence?
Excuse me, just as a demonstrative exhibit for him to just talk about. If you could, would you tell the jury, and I want to try to do this briefly and move pretty quickly, okay? If you could tell the jury how this describes what the roles of each were. And I'm going to go, for instance, your immediate below you was who?
Well, below me, not to the side.
All right.
Below me are the deputies.
Yes.
So the way the Office of Attorney General was organized when I was there and when I came in is there were divisions. So it starts on the left with Ruth Ann Thornton, who would have been Director of Child Support. And it goes all the way across to Darren McCarty, who would have been the Deputy Attorney General for Civil Litigation. And everybody in between, Lacey Mays, Deputy for Administration, Mark Penley, Deputy for Criminal Justice.
I think it'll be important to understand your testimony as we go along. Do each of these divisions heads have particular responsibilities of their own?
They do. I mean, they run a division in the Attorney General. Don't forget, the Attorney General's office is 4,200 employees, approximately 800 lawyers. And so spread out on this chart that's before us are the various divisions
Texas
of the office.
is a big state, I guess. 800 lawyers.
Over to the right, or your left as we look at this chart, but to the right on the chart, Mr. Bangert, what was his responsibility?
So Ryan Bangert was the Deputy First Assistant. So
Now, let me ask you this. If one were to describe where he comes down on the political scale, liberal, moderate, conservative, obviously each of these are Republican, are they not?
As far as I know, each of them are Republicans, yes.
All right. And Mr. Bangert, how would you describe his background and his views in terms of the way he dealt with issues that affect people in this country?
Mr. Bangert has similar views to mine.
All right.
He's a person of faith who's also a very, very good lawyer. He worked for Josh Hawley in Missouri. He had been a partner at Baker Botts. Very much aligns with me and quite frankly, all of our leadership.
And then if you go to the right of you on the chart, to the left of us as we look at it,
no, it's not. This is not Dick Armey. He worked for Dick Armey.
She's a career
His name's not Dick
OAG.
Armey.
Actually, her father was a Deputy Attorney General, and the joke was Missy grew up at the Office of Attorney General.
Do you have any evidence that she's a member of the deep state?
She's not a member of the deep state. She cares deeply about the Office of Attorney General in the state of Texas.
I'll be right back.
If we look at the different persons here, there's been a lot of talk about the whistleblowers. Obviously, you would be one, are you not?
I'm one of the 8 who signed the letter.
However, when we hear about the whistleblower lawsuit, did you file a lawsuit?
I did not file a lawsuit.
So as you sit there now, do you have any litigation pending against the Attorney General's office?
I do not.
Okay. Do you know whether Mr. Bangert filed a lawsuit?
He did not.
Are both of you among the 8 that sent a letter to the Attorney General announcing that what you had done, and after you had been to the FBI on September the 30th of 2020?
Yes.
Pardon me?
Yes.
Okay. Now, as we go forward real quick, what's the background of Mr. Brickman?
Yeah, so Mr. Brickman, he served as Deputy AG for Policy and Strategic Initiatives. The Attorney General and I recruited him into the office. He had been Chief of Staff for Governor Bevin, who was the Republican governor in Kentucky, and he had lost.
And widely known as a very conservative governor in Kentucky.
Governor Bevin was one of the most conservative governors in the country.
All right, go ahead.
And I had met Blake the first time I'd mentioned Federalist Society. One of the things that Federalist Society did is they brought together leadership from governor's offices and AG's offices.
And Mr. Mateer, were each of you very active, not just in your states, but nationally in conservative Republican politics, many of which considered the evangelical movement?
Yes, we were.
All right. And then who hired Mr. Brickman?
Well, ultimately, the Attorney General hired Mr. Brickman, but on my recommendation.
All right. And then if we go further, we have Mr. Maxwell there. Mr. Maxwell was there when you got there, correct?
Yeah, Mr. Maxwell, the way deputies is on the 8th floor, there's a conference room. Mr. Maxwell would sit to my right. He was the director of law enforcement.
And he actually had been there quite some time and had a career before you ever arrived, correct?
Yeah, I think he approaches 50 years of law enforcement. He's actually in the Texas Ranger Hall of Fame.
Mark Penley, who is he?
So Mark Penley came in after I came in. We had an opening for Deputy Attorney General of Criminal, and we interviewed several people. Mr. Penley had known Mr. Paxton for years. I think they'd been friends for over 20 years. They actually practiced together at a Dallas law firm known as Strasburger and Price.
Mr. Penley was also a career federal prosecutor.
He was. After he was I think he was an associate at Strasburger and Price, and then he went to the U.S. Attorney's Office in Dallas.
On the scale of 1 to 10, where would you yourself rank Mr. Penley in terms of conservative versus moderate?
I mean, again, I put him with the same as me and Bangert. I mean, he's at the end of the spectrum.
Mr. Maxwell, we talked about, is one of the ones who filed a lawsuit, correct?
Right.
And then Mr. Pendley is one who did file a lawsuit, correct?
That's my understanding, yes.
So thus far, and Mr. Brickman filed a lawsuit, right?
Yes.
We've talked about 5 of the whistleblowers so far, 2 who did not file a lawsuit, and 3 who did. Is that correct?
That's correct.
And then to the right of Mr. Pendley, who is that?
That's to my left. You're Ryan Vassar.
All right.
And
what do you know about the background of Mr. Vassar?
Ryan Vassar was a protege of Brantley Starr, now Judge Brantley Starr. Mr. Vassar had clerked for Don Willett and came to the Office of Attorney General after his clerkship. And Brantley, Judge Starr, took him under his wing. And he quickly established himself as one of the smartest, go-to, hardworking young lawyers in the agency.
And then Leslie Mays?
Yeah, Lacey is another person. She actually, I think, started as a elementary school teacher and then went to law school. She was identified by the former deputy for civil litigation, Jim Davis, as a rising star.
And she had also did not join the lawsuit?
She did not file a lawsuit, no.
All right.
She's currently Deputy Attorney General of Tennessee.
She's the number 2 person in the state of Tennessee now, is she not, in the Tennessee Attorney General's office?
She is, sir, yes.
Right. After this all over, were you aware she could not find a job anywhere in government in Texas?
I had heard that, yes.
All right. So to finish up on this particular subject, now that we've looked at who everyone was, to your knowledge, when each of these people joined the Attorney General's office here in the state of Texas, how would you describe their mission in terms of their devotion to the same things the Attorney General spoke very broadly and widely about?
Yeah, with all these individuals have in common, again, I told you I'm a Baptist, so I think of 3 C's. Okay, and the 3 C's are calling,
really,
character, and competence.
And what is calling? What do you mean?
Calling, and I know that.
Wait.
Sorry.
I actually had just 2 more words. If you waited just another few seconds. All right. But what do you mean by calling?
Okay. I know calling sounds like a spiritual term, but for me, it's really mission and it's commitment to the mission. And so when you're looking for people, certainly in leadership positions, whether it's at the Office of Attorney General, my current job at First Liberty, first thing I want in someone is someone committed to the mission. They're passionate about the mission.
And what were you committed to about serving as the first assistant for Ken Paxton's Attorney General's office?
We are committed to the rule of law and to conservative governance.
What's the second C?
The second C is competence. So it's one thing to be passionate, like I'm passionate about baseball, but I could never have played in the major leagues, right? But I'm passionate about it, but I'm not confident. So in addition to having passion, you've got to have competence. You've got to be the best. And I always felt like, whether it's at First Liberty, I want the best. At the Office of Attorney General, in senior leadership, you want lawyers who are skilled, people who are the best in their profession.
So the third C?
Is character. Because of the responsibilities, you have to have men and women who have integrity. And I actually would share this with new employees at the office, because this is what we wanted. In someone at the Office of Attorney General, you wanted passion, you wanted competence, excel, and you wanted character.
Mr. Mateer, in 2015, when you joined the Texas Attorney General's office, 2017, 2018, did you feel that office was in sync with the views you've just been expressing?
I think it was.
And then really 2018, 2019, did you think that office was in sync with the values that you've been describing?
I believe so, yes.
At that time, did you believe in Ken Paxton and all he was saying?
Absolutely, and I believe that General Paxton also possessed these characteristics. I wouldn't have come to Austin had I not believed he was a true believer.
All right. Did you ultimately change your opinion? And all I want is a yes or no.
I did.
All right. Let's take you on that road. When is the first time that you ever met? You're going to find me doing that a lot. I'm not used to it, but I'm going to do it a lot. When is the first time you met Nate Paul?
I've never met Nate Paul.
Oh, never?
Never.
When's the first time you heard his name?
Yeah, I've been trying to think about that. It had to have been sometime in 2020.
Do you have any reason to believe when it was?
Well, I've recently seen an email highlighting a public information request that I believe was sent at the end of 2019. It's possible that in early 2020, I heard the name the first time, but sitting here, my best recollection is I don't recall hearing his name until probably sometime in the spring of 2020.
So there was I think no one's going to quarrel with the idea that on August the 14th of 2019, this man that you still never met, Nate Paul, had a search warrant executed on his house and business, 4 different locations, by a combined task force of different agencies, Department of Public Safety, securities, FBI, all on his house. And I don't think there's going to be any question that he strongly objected and vociferously opposed what had happened and what he contended was the way. Do you have any, or did you have any memory of noticing anything about that in the year 2019?
I do not remember noticing that, no, sir.
So let's go then to the circumstance in which you would have first, if I could, let me, if I could, I moved to introduce Exhibit 628. Do you have the ability to show it to the president and the legal advisor? If not, you can give a hard copy.
Okay.
Before I move to introduce it, I'm going to ask if you would look at it and see. Yeah, you don't have it, so I'm going to move it to you.
Yeah, I don't have one.
May I give him a copy of this, Your Honor?
Yes,
Let
you
me
may
look
bring it
at
up.
just look at hard copy.
Okay.
Any objection?
I want to know. I want you to look at it and see. Do you receive fundraising emails from the Attorney General?
You know, I actually am on, I think my personal email does get emails from Mr. Paxton.
I want you to look at this very quickly and see if you have received a fundraiser email like this.
I believe I have, yes.
Right. I move to introduce 628, Your Honor.
Your Honor, this is it appears to be an email from Ken Paxton in June of 2023, which would have no relevance to this proceeding.
Well, I think we're now in the month of September, so it's in the past, and it's relevant as to who he says is behind all of while we're right here.
Well, if the email was from the future, that would be amazing.
Ask this witness if he feels that he's.
You heard it here first, people. The emails from the past.
You're testifying about the Attorney General.
Again, Your Honor, this man left the office in October of 2020. This is years later, has no relevance.
Sustained.
Excuse me.
I sustained his objection.
Okay. You can put that aside. Thank you. Now,
why are you showing emails from 2023? Are you a trial lawyer, sir? Maybe your co-counsel can do better.
Are you imposed of a radical transgender agenda?
Your Honor,
What?
objection from reading from a document you just said was not to go into evidence.
I'm just simply asking about a phrase. It is free. I got it from it, but I can put this down and do it.
Be best you put it down.
Thank you very much. Or do you find yourself an advocate one way or the other of a radical transgender agenda?
I mean, we represented people at First Liberty who've been persecuted because they had views that are described as being anti-transgender.
All right. Now, at the end of that, I want to go now to January of 2020. Did you receive?
Why'd you ask the question in such an inflammatory way? It's your witness.
Move to introduce.
Why would you ask the question in such an inflammatory way? I mean, his answer was much better than your question. Damn. What's your position on the radical transgender agenda? It's like, what? Why would you ask the question that way? And his answer is, well, we've represented people who've been fired because of their views on transgender issues, is a much better answer to the question. God damn.
No idea what that objection meant.
Objection privilege. I mean, this is communications in the office between lawyers, and the privilege is held by the Attorney General.
I would suggest it has nothing to do with legal advice in any way. It doesn't become magically a privilege just by the fact that two lawyers are on the email.
That's fair. That's true.
So, Your Honor, if you look carefully at the document, it's absolutely related to the legal advice, reconsideration of some sort of opinion. That's right in the strike zone of what legal advice is.
Excuse me. Is he tendering an objection, I may ask, on behalf of the Attorney General's office? This was an exhibit submitted to us by them.
Objection overruled. Continue.
All right, now, if you would, tell the court real quickly what this is. It should be on.
I'm not seeing it. Oh, now I see it.
Yeah.
Yes. This is an email that was sent from me to Ryan Bangert, unfortunately, on January 1st, 2020 at 9:01 a.m.
Yeah, is that y'all's normal practice there when you were there to be working on the first day of the year at 9 in the morning?
You know.
Yes or no?
Yes.
Okay. Now, did he have a little bit more restraint and wait to respond to you the next day?
Yes.
Okay. Now, in this particular email, did you do anything with this afterwards? Did you just simply forward to him and that was it?
The issue apparently was highlighted to me as something we need to take a look at, and I would have sent it on to Mr. Bangert for him to deal with.
So, do you know now from looking at what the issue was?
I mean, I do know the issue had to do with a public information request made by Mr. Paul and or his attorneys.
All right. And so but had you been involved in that at all, or would Mr. Bangert be the better person to discuss that with?
Mr. Bangert would be the better person.
As you sit there now, was this something at that time that you got involved in one way or the other?
It was not on, no.
Had the issue of the public information request having to do with law enforcement exceptions, had that worked its way to your desk yet at that time?
Not that I recall. I think this is the first time.
All right. So who would be, at that time, who would have been responsible in the Attorney General's office for the issue of public information request?
Justin Gordon.
Pardon me? Justin Gordon?
Justin Gordon.
And then if we went up the chain, who was above him? Do you recall?
Above him would have been, I believe it goes to, memory test. I believe it goes to, for me, it would have been Ryan Bangert ultimately, who was overseeing it.
And indeed, so when you got that request, when it says Aaron Borden, were you able to determine who that was? In terms of her position or context of why you sent the email?
Well, what I would have is Meadows Collier, and based upon the statement that I've made, we've been asked to take a closer look at this one. That means someone asked me to take a closer look at this one.
All right. And did you ultimately determine it had to do with a public information request by attorneys on behalf of Mr. DePaul?
Yeah.
All right. Now, is all you did was just send it on to Ryan Bangert? Is that all you did?
I have to be honest. I'm not really liking this attorney. I'm not really liking this questioning. I don't like his tone.
And getting ready for today, I don't recall.
I don't really think this is a particularly effective direct. He seems slightly confused.
When is the next time that you remember ever hearing the name Nate Paul?
I really think it was June of 2020.
All right. So we're in June of 2020, are we? And what was the circumstance in which you did that?
I think that's when is the first time I was introduced to an entity called the Minty Foundation. I think that's the name, Minty Foundation.
All right. Now, I'm going to move to introduce at this time, Your Honor.
This guy has been too long at the fair, man.
Before you do that, I want to admit Exhibit 559 that I rolled on into
Thank you very
the
much.
evidence.
No objection to this document.
Now,
It will be admitted into evidence.
thank you, Your Honor. What do you,
Yeah.
could you tell the jury very briefly?
Matthew, I appreciate what you say about the witness, but I'm not
This
sure
is
the
an
degree to which it's on the witness.
executive approval Memo.
I'm more inclined to
regarding,
blame the lawyer at this
and
point,
think-
but I don't
can't
blame your
read it,
analysis.
But I think it's regarding.
I'm more willing to cast this on the lawyer
It's regarding
for his
a
style.
request to intervene.
The lawyer is
into
not
a legal matter.
the lawyer is not
Now,
readily
let's,
facilitating
try to move this through this quickly.
ease of
If we-
answer.
Can you?
I feel like the witness is at least
process
partially trying to correct
particular that would call
for the lawyer's
a
question,
litigation
and
memorandum
that's partially
like
why it seems evasive.
So anytime we're going to
Right?
approve
The
some sort of
lawyer,
action, if
the
it's
lawyer who's
filing
being
a
questioned is
lawsuit
smarter than the
or it's
lawyer asking the
intervening into a
questions,
lawsuit,
and so his answers
we
are
have
trying to
in
correct
place
the
a
question,
process in which
and that's why it's coming off
lawyer in a
evasive.
division. So in this case, it looks like Mary Henderson, who it's
Yeah,
from,
I think that's what's going on.
would request an action. And in this action, we want to intervene into this lawsuit. So this memo sets forth the reasons why the Office of Attorney General should intervene into a matter. It then goes up the chain of command. So it goes up to her division chief, which in this case would have been Josh Godby, who was chief of, I think it was financial trusts or financial transactions and charitable trusts.
And then it goes up to who?
And then it goes up to the deputy over civil litigation, who's over all.
Thank you, Marianne, for the gift memberships. Always appreciate it. Thank you.
Ultimately, it would go up to me. And the way the DocuSign system works is, Mary signs it, then it goes to Mr. Godby. Mr. Godby doesn't sign it, Mr. McCarty doesn't see it. Once Mr. Godby signs, it goes to McCarty. Once McCarty signs it, it would come to me.
All right, so this is important, Mr. Materi, and I want to, because there'll be another occasion for this same process. How is the decision made as to who all is on this executive memorandum?
Yeah, we had to actually have a signature matrix, and depending on what the issue was,
okay,
we had and these were in place when I came in. And my understanding is they date back to at least when Governor Abbott was Attorney General, maybe even further back.
All right, so this process that requires everybody in the division and then up to you to pass off on it is designed to do what?
Well, I mean, the policies and procedures are there to actually protect us all and ultimately protect the agency and also protect the Attorney General.
All right, so in this particular case, if Ms. Henderson is recommending the intervention in a lawsuit. Is that right?
That's correct.
And and lawsuit says the public interest in a charity, correct?
That's right.
In that recommendation, what would have happened if Joshua Godby, the person right above her in the DocuSign matrix, if he said no, does that kill it?
If he says no, it kills it, and I would only hear about it if someone brought it to me.
So are we to understand that if Mary Henderson sent this recommendation above and it got to Joshua Godby, and if he said yes, then it would go to Mr. McCarty, but if he said no, that's it?
That's correct.
Okay. So in some actions that are being recommended, how many people was your system designed to work through before it got to you for approval?
Well, in this case, 3. In some other situations, it's even more people.
Okay. We're going to get to one that has to do with hiring outside counsel in a while. That had a lot more people that had to go through there, correct?
That's correct, because we were spending money.
All right. And that's what added people?
Yes. I mean, one of the reasons, yes.
And would it also add people if it crossed 2 different divisions' jurisdiction?
Correct.
All right. So here on this one, at the time of this one,
it's amazing they're able to get anything done in the Attorney General's office with all that bureaucracy. You need 4 different people to sign off on something. And if it crosses divisions, you need all those people to sign off on it too? It's like, damn, how many levels of approval do you need? Shit. It's amazing the Attorney General's office can get anything done. Damn.
This moment on June 6th, or is that 8? I didn't put my glasses on. Is that 6/8?
I think it
Yeah.
looks like the 8th.
Well, you know, if we want to bring the lawsuit, it had to be approved by this guy, and then it also had to be signed off by this guy, and then this guy, and then I'd see it, unless, of course, it had to be signed off by a different division, in which case we need their people sign off on it, so start the process over again. So by the time we get to do it, we got 8 people's signatures on it.
Something was coming. And so what best recollection is I probably have gotten that heads up. Yeah, I would have gotten a heads up.
Would you be aware that the line people in the past...
I'm beginning to understand why they need 800 lawyers.
And made an affirmative
for all those levels,
not
man.
To intervene in that lawsuit.
You know?
I don't think I was aware
if you need four signatures to get anything done, you know, you're going to need 800 people, so there's enough people to sign things.
And an entity controlled by Nate Paul.
You know, I don't know if I don't remember.
At this time, in June of 2020, had you become aware at any level of consciousness in your mind of Nate Paul?
Not in early June, I don't think
right.
so.
So we can safely rest assured that whatever you're going to tell this jury today is based on information that you got after June 8th of 2020.
That's correct, sir.
All right. So were you aware of any issue at the
Robert,
time?
you probably are right. You probably are right.
This time.
He even said as much in his questions, like it's designed to protect us and it's designed to protect the Attorney General. You're right. It's basically everyone is guilty, so no one is to blame. You're probably exactly right. Oh, it's designed to protect us and designed to protect the Attorney General because no one's responsible.
Multi-pages here.
No one's responsible.
Do you recall you would have, whether or not you would have read through these, or would you?
It wasn't me. It was the guy above me. It wasn't my fault. It was the fact that people below me submitted it.
Two answers. I would have relied on the people, but I also did read it.
Okay. Now, what did you think?
Robert's probably right. Bonus points for Robert. Cynical is correct.
Based upon Ms. Henderson, Mr. Godby, and Mr. McCarty's recommendation, this was in the interest of the state of Texas to intervene into this lawsuit.
Did you have any idea at that time whether Mr. McCarty thought it was a good idea?
I assume since he sent this memo, he did.
Were you aware one way or the other as to whether Mr. Paxton had any input in this decision?
I was not aware, no. That wouldn't be uncommon.
That would what?
It would not, I mean, because the Office of Attorney General, when I was there, it was over 30,000 litigation matters, cases, civil matters. So I didn't know about every one, and there's no way the Attorney General could.
So let me ask you, at this time, were you aware one way or the other whether Mr. Paxton was in contact with both Mr. Godby and Mr. McCarty urging this intervention?
In June, I don't think I was aware of that.
Okay. Did you later become aware of that?
In July, I became aware of that.
All right. But at this time, not, correct?
Not in early June, no, I don't believe so.
All right. Now, were you aware, had you ever dealt with the charitable trust to understand what the obligation of the Attorney General's office
I'm having bad flashbacks from the office space right now.
Yes.
But you had not.
I'm not a charitable trust lawyer.
Okay. And at June 6th or June 8th of 2020, were you familiar?
You know, when I screw up, I have 7 bosses come and tell me about it. Okay. 7.
Now,
7 bosses. That's my only real motivation.
67.
Not to screw up so I won't get yelled at 7 times, but you know, they'll only make someone work hard enough not to get caught. Yep.
I move to introduce Exhibit 67, Your Honor.
No objection.
Can you tell us what this is, please?
Admitted into evidence.
Excuse me, I'm sorry, I apologize, I jumped the gun on you.
No problem.
Can you tell us what this exhibit is, please?
It is another executive approval memorandum for civil litigation, and this one is a request to investigate, not the same as intervening, but to investigate a charitable trust, the Mitty Foundation.
Do you have any personal memory or anything about this event or why this one was done?
Other than it has my initials on it, I do not.
And it's a little later, is it not?
That's correct. It's, I think, the next day, June 9th.
Looks like.
And I sign it on June 11th.
Okay. Now, did you ultimately, I want to go if I can, were you having contact? You've talked about Darren McCarty, or we have, Joshua Godby. Were you at this time having any contacts with the line lawyers on this case?
Not with the line lawyers. My contacts would have been with Mr. McCarty. He had a one-on-one every week with me.
All right. Now, what was Mr. McCarty's primary duties at this time in the overall scheme of the office?
I mean, he was in charge of all the civil litigation. So all those 30,000 cases, they would be at Darren. However, his number one job, in addition to leading that, was we had two major pieces of litigation. One against Google and one that was a big litigation against the opioid manufacturers and distributors.
All right, and how much money potentially was involved in that?
Oh, billions of dollars.
All right, so let me ask you this. Mr. McCarty, how much of his time would you estimate he was spending on the Google case?
I mean, a fair amount of his time. I would say over 50%, because that was a major piece of litigation for the office.
Ordinarily, would he be pulled into managing or doing anything of a lawsuit this size?
You can't, we have 30,000 cases. I can't be involved in every case. The deputy for civil litigation, one that is not, I mean, obviously significant to the parties, but in the scheme of things for the state of Texas, that's very unusual.
Did you have any idea at that time why Mr. McCarty kept getting involved in this case?
I mean, in June, no.
All right. When did you become aware?
Mid-July.
All right. At this time, we haven't really mentioned the fact that we're talking about the era of COVID, are we not?
We are.
We're in the month of June. COVID was roughly, as far as the governor's proclamation and everybody running around on it, trying to figure out policy, that was the middle of March, right?
Yeah, I mean, the whole COVID effort took a lot of my time and Mr. Bangert's time and Mr. Vassar's time, quite frankly.
Do you have any explanation as to why people such as he and y'all were being involved in this kind of case?
I mean, we just normally wouldn't have been involved in this type of case.
All right. Now, I want, if I can, to go to Exhibit 147.
Okay.
Any objection?
I move to introduce you. I'm sorry, Your Honor.
No objection.
Are you a trial lawyer, sir?
Exhibit 147 into evidence.
It's up on your screen now. What is this?
Yeah, this is an email exchange between me and Mr. Nate Paul.
Well, how did it come about that you and Mr. Nate Paul were having email exchanges about?
I don't know, because it came out of the blue. He's in this email, he's asking to meet with me in person. As I testified to earlier, I had never met Mr. Paul. I'd never talked to him on the phone. At some point in July, I became aware of him. That must have been through the Attorney General, who would have alerted to me about him.
All right. So now this is dated on July the 17th, is it not?
It is.
You have any idea why Mr. Paul would feel so comfy asking you for an appointment that he's calling you Jeff, if neither one of you have ever met each other?
I can only speculate.
Were you aware by that time he was friends with the Attorney General?
I don't know if I knew what the extent of the relationship was. I knew they had a relationship by then, I think.
And so this idea that you would talk to him on the 17th, what was your three-word answer?
Remember, I'm Baptist, so it was, I'm not available.
All right. And why did you say you were not available?
Well, I knew at this time that there was litigation involving Mr. Paul. I mean, I would have known that, and it would not be my practice to meet with someone who's represented by counsel who is, I mean, they're not, it's an opposing party. It's just, they're involved in litigation that the state is involved in. That would just, I mean, beyond that, as a lawyer, you just don't do things like that.
Well, to put it another way, you guys were in litigation with Mr. Paul as one of the parties. Would you ever meet with him without his lawyer?
Well, we had intervened into a lawsuit.
Right.
And so we were in the middle of the V, so to speak.
All right. So is that why you told him you would not talk to him?
That is right.
All right. Now, I want, if I can, I'm going to, well, let's go now, if we can, to Exhibit 87. This last one we just looked at was July the 18th, right? You remember that?
July 17th and 18th,
Any
correct.
objection?
Hearsay, Your Honor. This document is hearsay.
Well, I wasn't filled with the question. Let's just. I haven't asked him. I haven't asked to admit it yet. I will.
Well, I just thought he had forgotten, but
So,
it's hearsay.
the two documents are, one is July 18th, and the one you're being shown now is July 22nd. Is that correct?
I'm not seeing it yet, but I do know I did
That's
a
a
memo
good
to the
point.
file on July
All right.
22nd.
Let me just walk up with you, show you the hard copy to identify it. It's not in evidence yet, so don't testify from it. Okay?
This is the best they could do. This is the best they could do for a lawyer.
Whether you recognize that.
I mean, you would think you would find, like,
Sorry, give me a moment.
you know, the best trial lawyer you could in
Give me
Texas,
a moment. I want to read through this on his.
right? Like someone, like, wouldn't you find, like, someone who has a lot of prosecutorial experience? Find the best prosecutor you could. And this is what you got. I am not particularly impressed with counsel over here. I am at this point openly questioning whether or not I could do a better job. And the fact that I'm asking that question is kind of sad. This is supposed to be the impeachment trial of the AG, right? Like, this guy should be crushing me every possible way. And I don't feel like he is. You know? It's like, if this is the standard I'm being measured by, I'm not sure I'm going to be embarrassed.
Are you submitting it?
Not yet. I will, but not yet, if that's okay. Did the court have something on your mind you wanted to?
Move on.
Thank you. I want to ask you now, back on that earlier email, Mr. Paul asked you for a meeting on a particular date, did he not?
Right, I think he wanted to meet the following week, that Monday.
Well, let's do for the record and the court real quickly. July 17th, let's go back if we could to 147.
He's primarily a defense lawyer?
Yeah, I've seen it.
Okay, well, that's not great.
That memo says, does it not? Or go ahead and read it out loud for the jury.
Yeah, it says, I hope all is well. Are you available for an in-person meeting on Monday, which would have been the 20th, I believe.
Well, that's what I want to do. Let's figure out the dates for the jury. Up above, we know when you said I'm not available, it was July 18th on Saturday, correct? So Monday would have been the 20th of July, is that correct?
That is correct.
Did you later discover there was any significance to meeting on Monday in terms of anything else that was supposed to happen that week?
Well, I found out on the morning of July 22nd that there was a hearing involving the Mitty Foundation case.
And on July the 22nd, that would have been a Wednesday, would it not?
That would have been Wednesday, yes, sir.
What time that day did you find out that there was a hearing scheduled for that day?
It must have been pretty early, because I normally arrived at the office 7:15, and I got a call that morning before I left for the office from Darren McCarty.
Did you later go back, Mr. Mateer, and figure out that the meeting Mr. Paul wanted on Monday the 20th concerned this hearing on the 22nd?
I believe that was the case.
All right, but not having met with him on the 20th, until you got to the office that morning or whenever you were contacted, were you aware before the morning of the 22nd that there was a hearing scheduled for that day?
I was not aware.
How did you become aware of that hearing?
Yeah, Mr. McCarty, the deputy for civil litigation, called me, and I remember being at my condo in downtown Austin. Again, had to have been sometime in the 6 o'clock hour, and he had advised me.
Objection, hearsay.
Yeah, he's certainly right. It is. So, after what did you and the others become?
Yeah, he's right. It is
about
okay.
what was about to happen, what was about to be proposed that morning.
I was concerned that the Attorney General was going to appear in Travis County District Court and argue a motion on behalf of the Office of Attorney General.
Well, why would that concern you?
Well, I mean, at the time, I couldn't remember a sitting Attorney General actually going into a district court to argue anything. I mean, the last one was probably Dan Morales.
What was your fear?
I mean, General Paxton has some wonderful qualities, but he is not a litigator. And to think that he would go into court arguing a motion just made absolutely no sense, and especially on a matter, I mean, this isn't the Google case. This wasn't a Supreme Court argument. This was, with all respect to those who practice in Travis County District Court, it was Travis County District Court.
All right. Mr. Mateer, as a result of your concern, did you organize a meeting?
I did organize a meeting.
Well, then, doesn't have a lot of feeling for the city of Austin there, does he? Okay,
Right.
damn.
And who all did you have at that meeting?
Well, I had Mr. Paxton, and I had Blake Brickman, and I had Mark Rylander, who was the Deputy of Communications.
Okay. And at that
Director of
meeting,
Communications.
what was your intent for that meeting initially?
I mean, I wanted to find out what Mr. Paxton was thinking, because, I mean, it was inconceivable to me that he would want to go to district court to argue something.
Did you know at that time on whose behalf the argument would have in effect been?
I think, Mr. McCarty, yes, I would have known.
And who was that?
Well, it would have been in the Mitty Foundation at the urging of Mr. Paul.
All right. And when you had the meeting, before you started talking about other things with the Attorney General, what did you discover in terms of whether somebody had changed his mind?
Well, I did learn that actually Mr. Paxton, that Mr. McCarty was successful in having the Attorney General not go to that hearing. He was persuaded not to go.
So then what did you move that meeting of July the 22nd? What subject did you move it to?
Well, it had to involve Nate Paul. I mean, just that the Attorney General being involved in matters like the Mitty Foundation, things, again, that were not significant litigation matters at the Office of Attorney General.
By that time, and by talking to other deputies and information, had you become...
Maybe the Attorney General just wanted to slum it for a while. He wanted to come down with the normies and just slum it on a basic case.
So during that meeting, did you take any...
Change of pace, you know?
Urge him in any way?
Keep yourself sharp, I don't know.
Nate Paul.
Objection, hearsay. And also, it's privileged, Your Honor.
I think we're...
That would be kind of fun. Would it be kind of fun just to be like the Attorney General or something and just pick like some random banal case and just slum it and show up at some trial of a court and like, yeah, who's here on behalf of the Attorney General? The Attorney General?
Sure.
Just to like blow everyone's minds.
Okay. Now,
that could be fun.
In that meeting, did you yourself make any particular urging of the Attorney General?
Objection, hearsay, and also privilege.
Object on both grounds. I haven't asked him for the statement.
Overruled.
Thank you. Did you?
I did.
And what did you urge him? Is it regarding Nate Paul?
Again, Your Honor, this is hearsay, and also it's him advising the Attorney General, which is privileged communication.
First of all, the Attorney General is not here, and he doesn't have the right to claim an attorney-client privilege. There is no personal attorney-client privilege for him. The only question would be as to whether the Attorney General's office had the right to invoke it, and I respectfully suggest they do not.
Overruled. Move along.
Thank you. So, what did you urge him?
I urged him not to have any further dealings with Nate Paul, to let the lawyers, the professionals in the Office of Attorney General, handle these matters as they saw fit.
What was the Attorney General's response?
He committed to that.
Objection, hearsay. Also, it's a communication, Your Honor.
I think this comes out of the party admission, Your Honor. This is, I think, clearly admissible. In terms of the Attorney General, he's the party, and this is an admission being offered as admission by him.
Overruled.
Go ahead.
The Attorney General committed to me with Mr. Rylander and Mr. Brickman in the room that he would have no further dealings, that he would allow the office, the professionals in the office, to handle the matter.
How long was this meeting that y'all were in?
I guess 30 minutes or so, maybe 45 minutes.
Now I'm asking you demeanor and manner as opposed to actual words. How would you describe how insistent you were in your urging of him to have no more contact with Mr. Paul?
It was very troubling to me that the Attorney General would be willing to appear in Travis County District Court. So I was very concerned that why he would want to do that when we have, again, 800 attorneys at the Office of Attorney General who are very capable.
My question is, how insistent were you?
I was pretty insistent.
Obviously, you recognize he had the right to talk to anybody or help anybody, you thought, right?
Well, and I wanted in this meeting, that's why I had Mark Rylander there. Because Mark Rylander, his title was Director of Communications, but the joke in the office was I was first assistant and he was first friend.
All right. So in this meeting, how would you describe the demeanor or earnestness or lack of or whatever the Attorney General's outward response when he told you he would not do it anymore?
He seemed sincere to me.
When you left that meeting, what did you believe in terms of the Attorney General's conduct in the future or contact or attempts to help Mr. Paul?
I was hopeful that he would allow the professionals in the Office of Attorney General to do their jobs and he wouldn't be involved anymore.
All right. Were you surprised to discover later that the very next day he's contacting other assistants on other matters to help Mr. Paul?
Surprised and disappointed, yes.
All right. During the time from July the 22nd, from then on, after his assurance that he would have nothing more to do with Mr. Paul, did you become aware that his contacts with Mr. Paul had become even more frequent?
I did.
Did you become aware that those contacts that were much more frequent also touched a broader variety of activities?
I did.
Than
yes.
just charity?
Yes.
Okay. At this time, Your Honor, I will move to introduce what my number.
All right, so we're finally getting somewhere. It's not great, and we spent a lot of time dicking around, but at least we're getting somewhere on the idea that Ken Paxton was going out of his way and doing things that would be abnormal for the AG for the benefit of this particular guy. Like the AG doesn't normally show up in district court, but he's showing up in district court specifically because it's this guy.
Attorney General.
So yeah, it could be that.
This talks about communications between client and lawyer. This is a privilege issue square and away.
Yeah.
I already admitted 87. Overruled.
So we're getting some useful stuff,
if I could,
but we're spending a lot of time getting there.
I want to ask you to move on to another exhibit, but let me ask you something before I go there. That meeting was on the 22nd, and I apologize. I think when you were out talking, I may be dropping my voice some here. I'm hoping people in the back can still hear, but let me make sure they can at this tone of voice. And did you ultimately respond to back where you and I were before, to anyone about the particular request that had been made of you by Mr. Paul to meet back on that Monday? Remember, on the 17th, he asked to meet you on the 20th, correct?
I think at some point, Mr. Paul's lawyers send me either a letter or an email, which I respond to, again, I think by email.
All right. What I want to do is, if I may step over briefly, if I may have your permission to get the number.
Did the AG show up in the Rittenhouse trial? I think the AG might have been in the room. I don't remember the AG actually performing any functions. But I feel like the AG might have shown up at Rittenhouse or Floyd or something like that. I don't remember them doing anything, but I think they might have been there. I think you might be right. Sounds vaguely familiar.
Let's see.
Oh, the AG showed up in Murdaugh. The AG showed up in Murdaugh. That's right. I think maybe that's what we're thinking of. The AG showed up in Murdaugh. He didn't participate, but he did show up. Yeah, Murdaugh. He showed up in Murdaugh's case. Yeah, that's right.
Thank you. I've been corrected by somebody who knows much more than I. I really should be talking about 161. It's the same document, but I gave it the wrong number in my questions. Now,
You have it?
Stella, excuse me, did we give him one?
Did the AG take a witness in Murdaugh?
Army, if we can just find one in another book. I'll give him mine until we get it. But,
Mr. Harden, you want? I've looked at it if you need it. I think I remember it.
here's what I'm asking. Now that you've had a chance to look at 161, does that refresh your memory as to when you then responded to his request?
Was part of the closing?
Back on the 20th.
Okay.
Yes, it does.
All right. And when did you? We've gone through the meeting on July 22nd. You've had the conversation we heard about with the Attorney General. And then now you've moved back to July 24th, 2 days after the meeting with the Attorney General.
So he took a witness? That's pretty cool.
And so then did you sit down and draft a memo and respond, rather, to whom?
Well, to Mr. Paul's lawyers. And actually, I didn't really know who they were at this time. And so I was asking for information so I could adequately respond.
Yeah, I got it. Yeah. All right. So here's what I wanted to do. The reason I stopped without giving the name, I wanted you to give it. At the time you received a letter from Mr. Paul, did you even know who his lawyer was?
I did not or didn't remember.
All right. So then when you checked around, did you become familiar with whom you
know the AG is showing up in the Trump case,
and
right?
Who was that?
Well,
There's no chance whatsoever the AG doesn't show up in the room. Even if they can't do anything, there's no way the AG doesn't show up in the room for Trump. Put myself right there in the center, man. I'll be there every fucking day.
That time period.
And
scowling from the gallery.
Had you, by the time of the 24th, looked at the history of correspondence with Mr. Paul in terms of the way he talked to your people?
I mean, he attached in his email to me, he attached.
Is this the email? Excuse me. Is this the email back on the 17th?
I think it's a later email.
All right. And what did he attach for you?
He attached correspondence that he had with primarily Mr. Godby, in which he's complaining to Mr.
Trump needs a lot of legal help.
Exactly. Was he complaining about the treatment he was getting?
Trump needs a lot of legal help.
In the Biddy Foundation lawsuit from Mr. Godby?
Yes.
Was he complaining that he kept writing Mr. Godby, he the party, writing the lawyer for the other side? Was he complaining in constant emails about Mr. Godby?
That's exactly what he was doing, yes, sir.
And Mr. Godby, because he's not supposed to talk to a represented person, had done what?
He had not responded, which would be what any lawyer would do. You don't respond to the client or of the potential opposing party, you respond to their lawyers.
Right, it's against the rules of ethics.
The letter, actually when you were getting ready to write him on the 24th, did you have occasion to review that correspondence?
I did, yes.
And that's why I move, if I could, Your Honor, to 161.
I move if I could. Is that a motion to admit, or what are you doing?
The issue keeps coming up. As you can see on the document itself, it says this is attorney work product communication regarding a pending litigation matter. I mean, it's labeled as such, and I would suggest to the court that all of these types of emails are in fact work product or attorney-client privilege communications, and the only individual in that office who holds that privilege and who can waive that privilege is the elected Attorney General.
No.
I'm sorry for laughing. I have to, so this is when...
It would be, if it belongs to the Attorney General, Ken Paxton isn't the Attorney General.
This is actually his exhibit that we...
That doesn't even make sense. If the AG is the one that can waive the privilege, Ken Paxton isn't the AG.
By us to him because it was one of his exhibits.
So ask the AG.
Hold on, I'm not quite sure how he can now turn around and make a bunch of
that doesn't make sense
to an exhibit that he agreed to pre-admit. That we agreed to pre-admit and he accepted. It's his pre-admitted exhibit. It's in evidence, is my point.
I'm very confused because that was very confusing, but I would suggest this to the court. They put 161 on this as if it was their exhibit and moved it into evidence, and you asked for my objection.
Yes.
161 on their exhibit list is not this. So, I mean, first I guess we need to figure out what exhibit he's actually trying to offer. And if he's really trying to offer this, it ain't the right number. And if he's offering something that's already in evidence, then obviously I wouldn't object to it. But I'm very confused about what he's trying to do.
The court is very confused too.
I suggest he talk to, like I did, talk to someone on the side that knows more than he does about this. If he notices that exhibit that we introduced is AG 161. That's the Attorney General 161. I think if he checks with his people, he's going to find that's their exhibit that we agreed to pre-admit.
I didn't have any discussions with Mr. Harden. I mean, I know he's accused me of being recalcitrant. I haven't had any discussions about the exhibits, but my colleague, Dan Cogdell, has. As I understood it, they weren't going to object to any exhibits that we offered. They have no objections. But we had exhibits on our list that we may not offer. So I think that's probably what the dilemma we have, but I'm going to turn it, if you don't mind, since I didn't talk to Mr. Harden personally, maybe Mr. Cogdell can enlighten me.
I again suggest he talks to someone who knows something about the subject. I've just been handing my message, and I'll be glad to tender to the court where they have...
My money's on the AG office right now. Between the two of them, as to who's wrong, my money's on the AG office. This guy's not instilling me with confidence.
No, you're offering our exhibit. I mean, when you say 161, that presupposes you're offering your exhibit 161. That's why
yes,
I'm
it does.
At your list, and this ain't your exhibit 161. Now, with
yes, it does.
Whether these were pre-admitted or not, I would turn it on to Mr.
Yep, I'm with the AG.
Him objecting to us at this extended time. This may
you didn't offer AG 161. You offered 161. Meaning your exhibit 161, because you didn't say AG 161.
In my conversation.
So they thought you meant your exhibit 161, not their exhibit 161, because you're an idiot.
Notwithstanding, in my conversations, both orally and
oh my God,
with Ms. Bravorka, I very clearly stated that while I appreciate their not objecting, we did not intend to offer all of our exhibits. Many of our exhibits were marked for identification purposes only. For
right.
Impeachment, for whatever. So I never said, just because you didn't object to them, we want to...
The AG's office is right. The AG's office is right.
I think we may be raising gamemanship to a new level.
No, you're an idiot.
It is their exhibit. They asked if we would agree to pre-admit. We agreed to pre-admit. That put it in evidence.
No, it doesn't.
No, it doesn't.
No. You agree to admit it. Doesn't mean that we are offering it. Exactly. The AG's office is 100% right.
Coming in.
Exactly correct. Hey, do you agree to pre-admit this? I sure do. Fantastic. That means it's submitted. No, it doesn't. I haven't offered it yet. Oh my God.
We do not intend...
You've just agreed that if we offer it, you're not going to object, but we haven't offered it.
I'm glad we don't have to poll the kids in the upstairs as to what they think about this exchange. We've now used...
I know what I think. I think you're wrong.
On them objecting to their own exhibit. I tender 161.
Which one? Which 161? Which 161?
I said, I'm glad that we do not have to poll...
Oh my God.
...in the balcony as to whether this exchange makes any sense.
It does.
I think we've taken about 8 or 9 minutes now on something where y'all are objecting to your own pre-admitted exhibit.
It's not pre-admitted.
Again, they're not pre-admitted. They haven't
Thank you.
been offered. We never said, if y'all don't object to them, we're offering all of them. To the contrary.
The AG's office is right.
I'm going to take a 5-minute break.
The AG, this is what happens because the lieutenant governor is not a lawyer. The attorney general is completely correct. This guy is an idiot. This is moron shit. Okay? So first of all, let's just go through what happened, okay? Defense lawyer says, or prosecution lawyer, I apologize. Prosecution lawyer says, I'd like to offer Exhibit 161. The Attorney General office hears 161. What do they think he means? They think he means his Exhibit 161 because that's what the reference is, like 161. So they take a look at their evidence sheet, right? They take a look at their evidence sheet. They say his Exhibit 161. We have no problem with this. Exhibit 161 is fine by us. Now he starts using the document. And the Attorney General's office says, wait. This hasn't been admitted office. This hasn't been admitted. What are you doing? And he says, you admitted it. This is 161. And it's like, no, this document's not 161. What are you talking about? And then he says, oh, it's your document 161. It's AG 161. And the Attorney General's office is over here like, but you didn't say AG 161. You said 161, which means your Exhibit 161, which is completely correct. You're the one making the offer, right? When you said 161, we inferred you meant your own Exhibit 161, which would be how any attorney would understand it. Any attorney would understand it that way, right? So the AG is not being cute or difficult. They're being completely correct. You said 161. We thought you meant your Exhibit 161, not our exhibit. And so, like the Attorney General's, so that is like what I thought the Attorney General's exhibit are objecting to their own exhibit. Yes, we're objecting to our own exhibit. Well, I thought we agreed that you would ask me if we pre-cleared all your exhibits, and we said yes. You asked me if we pre-cleared all the exhibits, and you said yes. So it's admitted. No, we haven't offered it yet. We asked you in advance, do you have any objection to any of these exhibits? If we choose to offer them, do you have an objection to them? That speaks to nothing about what we have an objection to, right? You just made some sort of assumption out of nowhere that just because we asked whether or not you had an objection, that meant that we didn't have an objection. But we didn't make that representation. We didn't pre-admit everything. We didn't stipulate to admissibility. All that you stipulated to is because you're an idiot. All you stipulated to is that you wouldn't object. That doesn't bind us. And so they're like, okay, so we don't admit this. We don't agree. And so the attorney's over here like, oh, it's all confusion. It's all confusion, and the guy who's offering it is confused. The Attorney General's office is completely correct. Now, where I think they're wrong, where I think the Attorney General's offices is wrong, is like, this is a privilege that belongs to the office of the Attorney General. First of all, it's not the Attorney General's. First of all, it doesn't belong to the Attorney General. It belongs to the office of the Attorney General. So the privilege belongs to the office of the Attorney General, not to the Attorney General. There is a distinction, right? Because whoever is Attorney General at the moment, right? It would be the same of like any corporation, right? The privilege doesn't belong to the CEO of the corporation. The privilege belongs to the corporation. The CEO might be the one at that moment who can speak for the corporation or not, but the privilege doesn't belong to the CEO. The privilege belongs to the corporation. Same kind of idea, right? So he's like, okay, the privilege belongs to the AG. No, it belongs to the office of the AG. And then he says, well, only the elected AG is the one who can waive it. No, because the elected AG is not the AG. The AG has been impeached, and in Texas, that removes you from office effective immediately. So the elected AG is not the AG. The AG is whoever's standing in their stead. So it is not up to Paxton. It's up to whoever the AG is at the moment, which isn't Paxton. So I don't know what the AG's position is on this stuff at the moment, but it's not an issue. Did you ask the AG? Did you ask the AG whether or not they waived privilege or not? Did you even bother asking? Do you guys know who the AG is right now? How do I understand Texas law better than you do? I've only been a Texas lawyer for a year. How do I understand Texas law better than you? This is very sad. Did you ask the AG? Do you know who the AG is, sir? It isn't Paxton. So even assuming that only Paxton was the one who could waive it, no, because he isn't the AG. So you're both wrong and you're both idiots. Although I suspect the AG's office knows that, I suspect the AG office knows that, and they're just trying to hope that they won't notice. Because right now it seems like they won't notice. So I suspect the AG's office knows that Paxton isn't the right person to ask, but they're not going to make that particularly clear, because if you don't know the difference, why should we tell you? Yeah, the acting AG represents the office, correct. So if you need the AG to waive it, ask the AG. It isn't Paxton. Yeah, so that's what's going on. And it seems like the prosecution's lawyer is too dumb to notice. He's too dumb to notice the difference between the exhibits. And he's too dumb to notice that it isn't Paxton who he should be asking. Where's the AG? Where's the AG? Get the AG. Ask the AG. Hey, AG, can you waive everything? Can you waive privilege? I mean, if that's the issue, we'll get the AG to waive privilege. And if they won't waive privilege, then, look for ways to beat privilege. But, did you ask? Robert says, so if you are the CEO of a corporation in Texas, all my privileged conversations with corporate counsel can be waived by my successor? Correct. Correct, Robert. That is 100% correct. If you're the CEO of a corporation in Texas, all of your privileged communications with corporate counsel can be waived by your successor because the privilege isn't personal. The privilege isn't personal. It's your corporate counsel. The privilege belongs to the corporation, not to you. Remember, when you're thinking about attorney-client privilege, right, the privilege belongs to the client. So if it's corporate counsel, who's the client? The client is the corporation, not the CEO. The privilege belongs to the corporation, not the CEO. So yes, your future CEO can absolutely waive all conversations that you had because they were never yours. You were only there you were only there speaking on behalf of the corporation. If a future CEO wants to waive your privilege, they absolutely can, because it was not personal. It never belonged to you. Right. Correct. 100%. Yeah. Robert says, I bet a lot of people don't know that. Yeah, well, but you just have to think it all the way through. Right? Just think it all the way through. Right? It's like it's logical if you just think about it for a second. Right? If it's corporate counsel, who's the client? The corporation. Is the CEO the corporation? No, they're not. The CEO is not the corporation. Even if it were a one-man show, the CEO is still not the corporation, because this gets into that whole idea of corporate personhood, right? There's a distinction between the corporation and the people that run the corporation, even if you're dealing with like a sole owner, right? There is Uncivil Law LLC, but that's distinct from me, even though I'm the sole owner of Uncivil Law LLC. The corporation is a distinct legal person from me, right? So in the event someday I were to sell Uncivil Law LLC, then all the assets of the corporation get sold, including whatever privileged conversations I would have with whatever corporate counsel Uncivil Law LLC is talking about, because that's not me, right? So, yeah. Exactly correct. Matthew says, big surprise. Kurt's on point. Yeah, Kurt understands it. Kurt understands the law. Kurt understands the law. So I don't know whether or not it's true, by the way. This all assumes, by the way, that they're correct on the premise that only the AG can waive the privilege, which I don't even know if that's true, by the way. I don't know that well enough, but I do know if only the AG can waive the privilege. Ken Paxton isn't the AG. Ask the AG. So, would you like to do that at any point? I'm sure the AG is taking note of these hearings. Would you like to give him a call? Or maybe you could just walk over there. The AG is probably nearby. Where are the AG's offices? They're probably in the Capitol. Right? In fact, I'm pretty sure the AG's offices are in the Capitol. So just walk downstairs and, down the hall, knock on the door. Hey, AG, can we have a waiver of privilege? Sure. I don't know. Whatever. Yeah, Matthew Harris Law PLLC. Right. It's a Texas entity. Correct. Matthew Harris Law PLLC is not Matthew Harris. Right. Matthew Harris Law PLLC is not Matthew Harris. In the event that Matthew Harris Law PLLC is ever acquired by Uncivil Law LLC, Uncivil Law LLC can ask corporate counsel for Matthew Harris Law PLLC about all the super duper secrets of Matthew Harris Law LLC PLLC, and they will tell me because I am the client. Fun. Ruby says this is an impeachment trial. Paxton is still the AG. He was elected. Not in Texas, no. Not in Texas, no. Unlike the federal system, where an impeached officer remains in office while the trial is underway. In Texas, not so much. In Texas, the moment the impeachment is voted on by the House, the impeached officer is immediately suspended from office. Ken Paxton is not the AG. Because in Texas, having been impeached, they are unable to hold office while the Senate is pending. So no, not so much. Yeah. Yeah. They're a couple blocks away? Okay, fair enough. Then they can walk the couple blocks and ask. Go knock on their door. Give them a call. Hey, can we go out for drinks? Can we get you to sign on a cocktail napkin or something?
I need quiet in the courtroom, please.
Do you think the current acting AG has a massive conflict of interest? Well, not any more than not any more than Ken Paxton does. So, I can think of at least one person who has a bigger conflict of interest than the acting AG. Ken was elected. That's true. He was elected. That is correct. Ken Paxton was in fact elected as AG, but he's not the AG, at least not at the moment. When we're trying to find out if it stays that way. The more you know, right? It's one of those little eccentricities of law. You know, I do love this channel because every once in a while I learn something I didn't know. It's great. You know, like for example, yesterday or recently, I learned that South Carolina doesn't have, you can't use voluntary intoxication as a defense in a specific intent crime in South Carolina, which I thought was pretty weird. I thought that was pretty weird. I was like, I didn't believe it. And then I read the jury instructions. I'm like, oh, okay. But I thought it was pretty weird. You can't use voluntary intoxication as a defense in a specific intent crime? Okay, South Carolina, you do you. It's like, I didn't know that because that blew my mind. It didn't blow my mind as much as when in the Floyd case with Chauvin, it really blew my mind when we used the underlying assault as the predicate felony for felony murder. Because I'm like, you can't do that. You can't use the underlying assault as the predicate felony in a felony murder. That doesn't make any sense. And then I think I read 5 different state Supreme Court cases before I was convinced it was the law, because it was such a mind blow to me. It was such a mind blow. I didn't believe it. I don't think I believed it the first 4 times I read it. It's like, I was like, the Supreme Court can't possibly mean that. You're right. It's one of those things like you keep reading case after case after case, and you're like, the courts can't possibly mean this. They can't possibly mean what they're saying. And then you get to the 5th case, and you're like, okay, they actually mean it. You know, it's like, because you can't believe what they're saying. It's such a mind F. Or where New Mexico decided for some reason that spousal privilege isn't a thing anymore. Because spousal privilege is apparently really, really antiquated. And so they just abolished spousal privilege as a thing. Out of nowhere. It's like, what do you mean it's not a thing? Apparently it's not a thing. The law is complicated, people. It's complicated. It confuses me. This confuses me. Someone in chat said, it's weird, but I don't know. If one spouse could be in danger, it might be if the other testified. Yeah, spousal privilege doesn't apply in that situation. Spousal privilege doesn't apply in any state I'm aware of if the spouses are in opposition to each other. So if you had a domestic violence case, I don't believe spousal privilege applies in any case because the parties are in opposition. So that's a common exception to spousal privilege anyway. So that wasn't the reason. The reason was because apparently the idea of spousal privilege goes back to the idea of like men owning women or something. I don't know. I don't know. You learn new things every day, man. You learn new things every day. And every once in a while, they're like, you can't do that. And sometimes they're like, oh, yes, you can. Like, okay. This prosecutor doesn't seem like a lawyer. He's not the baddest I've ever seen. This lawyer seems a lot to be desired. Mr. Barstow said, did he intervene to protect someone from a legal case against the state? I forgot the context in which he said the AG's office intervened. It wouldn't be like unheard of for an AG's office to intervene in something as an interested party. Because, they're out there to protect the state law. So. Spousal privilege was left in the hands of those testifying. It depends on your state. Look, I don't know every exception to spousal privilege that exists. So, and then there's also whether it only covers words or whether it also covers actions. There's differences there too. So does spousal privilege only extend to the words between spouses, or does it also extend to observations, behavior, so forth and so on? So there's a difference there on law. Privilege is complicated. Your state law will get involved rapidly. And then there's another fun one where there's a split of authority on whether spousal privilege survives divorce or not. That's fun. So you tell your wife something in confidence now, and then you get divorced. Does the spousal privilege still survive the divorce or not? There's a split of authority on that. How complicated do you want to make this? So there's a split of authority on whether or not it survives divorce. There's a split of authority on whether or not it covers observations and behaviors and acts. There's a split of authority. Yeah, there's splits of authority all over the place. Yeah. South Carolina, those airplane bottles almost makes me want to go buy a huge bottle just because I can. Yeah, they changed that in 2004, at least in bars. I grew up in South Carolina. South Carolina didn't used to have free pour. You know how like you go to a bar and they'll have like a bottle of liquor and they'll pour you the alcohol from a bottle of liquor, you know, like at a bar? Not so much in South Carolina until 2004. Until 2004, they didn't have bottles that they poured you liquor from. They had airplane bottles. And they'd crack open an airplane bottle and serve you out of that. On the plus side, it did mean that all your drinks were very consistent. Because like you would always get the same amount of alcohol because they were measured bottles. So there was that. At least it led for a more consistent experience. So that was nice. But yeah, South Carolina didn't have free pour. It was mini bottle only until 2004. I lived there. I know. Can a spouse waive privilege? Sure, spouse can waive privilege, sure. You can always waive privilege. This is all assuming that you don't want to waive privilege. You know, what is the scope of the privilege? You know, before we can talk about whether you can waive privilege. Sure, you can always waive privilege. Yeah. I'm still doing private clubs to get around blue laws. I don't think they've had to as much because I think also in 2004 they started allowing Sunday pour, right? So there used to not be any liquor on Sundays, or you couldn't even get wine at like a restaurant on Sundays, which was a pain in the ass. In 2004, I think they changed that too, so that you could get alcohol on Sundays. So I don't think private clubs are as much a thing as they used to be. My 21st birthday was on a Sunday. I had to get someone to take me out to a private club so I could drink. It was fine. Sunday pour and Sunday beer wine sales by a county municipality. Yeah, that sounds probably right. I believe that. It wasn't a statewide thing. It was by county by county. I believe that. That sounds fine. For everyone watching, by the way, just a friendly reminder, as always, to please check out the channel. Let's listen to a little bit more of this Murdoch conference while we're waiting for whatever this is.
Posed with juror 785, and the judge actually said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and happening it to me."
And that's a good point. There's no suggestion that the judge did anything untoward. But what that does do, if it comes back, he may end up being a witness. So, I mean, but until the Court of Appeals acts, that issue does not have to be dealt with.
But if the fact is that the court was aware of some of these issues but still didn't intervene, how concerned are you?
We don't know. We don't know that he didn't intervene. That's what I'm saying. He's a witness. We need to know.
Do you feel that this evidence is strong enough such that it could have changed the verdict had it been introduced in trial?
You know, that's not the legal test. The legal test is the subject matter prejudicial to the defense. It's not would it have made a difference in the outcome. Was the subject matter of the improper private conversation material to the defense? If it's immaterial, like what do you want to have for dinner? Do you want to take a smoke break? Do you want to go home? Those are immaterial matters. But when the subject matter is, and is reported under oath by these jurors, it was a direction on how
Members, we're going to, with a couple of issues to deal with. We've worked with both parties. They're going to work on the exhibits this evening, and then we're going to deal with the privilege issue in the morning before we start trial. So we're going to adjourn for the day now. You're to be back here at 9 a.m. tomorrow morning, which means in the dining room at 8:45, ready to walk out at 8:55.
Okay. So they're dealing with privilege issues or whatever, so they'll deal with that. Did you ask the AG about what they think? Does the AG have an opinion on the privilege issues? You know. And can anyone else waive privilege? Because it belongs to the office of the AG. Maybe. Possibly. Who knows? We're just trying to solve these privilege issues now. These feel like something we should have dealt with long ago. But okay, whatever. So I guess we're adjourned for the day. Back to Murdaugh.
You should look at him. Don't be fooled by him. That subject matter is absolutely material. That's the core of our defense, and that is something that we had no chance to defend against. And so we strongly believe if that evidence is accurate, and the law will require a new trial.
So when was the last time you spoke with your client? When was the last time
No
you spoke
comment.
with your client, and what has he shared with you with this latest motion?
Well, I can't talk about attorney-client privilege information. I can tell you that when I shared with him the affidavits, he's a lawyer, he was astonished, he was shaking, he was in disbelief, and he thanked Mr. Harpootlian, Mr. Barber, and myself for spending our weekends on dirt roads in Colleton County.
And by the way, we've seen more of Colleton County on dirt roads, in places we're city boys, we didn't believe existed in this state, looking for folks that would talk to us. A lot of doors slammed in our face. A lot of doors slammed in our faces.
Do you think Ms. Hill should still have her job?
I'm sorry?
Do you think Ms. Hill should still have her job?
No comment. I'm sorry, what?
The Facebook posting from the ex-husband of the dismissed juror. There's a lot of detail in there about that. And there's some in-camera transcripts there as well. Was this not something that was just handled very quickly? The fact that you guys are alleging it didn't exist at all and perhaps was conspired to be created to get this juror dismissed?
Yes.
That's a very serious allegation.
It's all serious. Everything we've alleged, everything in those affidavits is serious. This is a very serious matter. And again,
So what you see in the sworn testimony that's been filed today is Ms. Hill told the court that there was a Facebook post by this juror's ex-husband. The ex-husband has filed an affidavit saying, I've never posted a Facebook post. Ms. Hill in her office says he must have deleted it, we can't find it. But they produced a Facebook post from someone with the same name apologizing for an earlier Facebook post and that Satan made him do it and et cetera, et cetera. And Ms. Hill related that as being this juror's ex-husband. Ms. Hill had this juror's ex-husband's photograph. You can match them up. They don't match. And what we do know, and we laid it out in detail in our brief, is that the apology Facebook post was posted, I think, on February 16th and said we had deleted it the day before, February 15th. Ms. Hill is telling Judge Newman on February 23rd that I just saw this Facebook post. Impossible. Impossible. We also have in there sworn testimony that Ms. Hill told this juror that SLED went out and confirmed with your ex-husband that he posted that. Not true, according to the sworn testimony.
And Phil Barber and I and Howie Miller from my office went down and interviewed the ex-husband, and he allowed us to, I wouldn't know how to do it, but Phil did, to download his entire Facebook history. None of that is in there. So, I mean, again, we've done what we can do. We're not the police. You know, we have no way to compel anybody to talk to us or give us anything. We've asked very nicely. Now, I will say this. The two jurors that gave affidavits have an attorney, Joe McCullough, who was skulking around here a moment ago back there. So if you want to know about those two jurors, you may want to have a chat with him.
What's the motivation of the jurors talking to you?
Wait, what?
What's the motivation, do you think, of the jurors talking to you? Are they upset with the clerk?
I think they were upset with the way things went, and the clerk, I think they may very well, yes, they're upset with the clerk. They're upset with the way this played out.
Are they regretting their vote?
Can't comment on that.
So the Facebook post, the person who posted the original post, have you ever gotten an opportunity to speak with them? And if so,
No. I mean, the original post, we don't know whether it ever existed.
But the apology post, did you speak to him, Phil?
No, we did not speak.
The timeline from the FBI
Well, as you know, having talked to the FBI before, no. They're not going to tell us anything.
In your letter to the U.S. Attorney, you mentioned the importance of having the FBI investigate as opposed to SLED, for example. Can you talk about the importance of having the FBI involved?
Well, having anybody but SLED investigate it. SLED is very invested in this conviction. How invested? Well, the agent, David Owens, that testified under cross-examination by Jim, admitted two things. One, he perjured himself in front of the grand jury. And two, he fabricated evidence. SLED made him this year's Law Enforcement Officer of the Year. So is that
Of course
the
they
agency
did.
that ought to be going to jurors?
Of course
I
they
don't
did.
think so. I think that the
Of
court,
course they
whenever
did.
this is remanded back, the trial court should pick somebody else. If the FBI is not doing it, then there are plenty. There's the sheriff's departments. There are other folk, not Colleton County, but other sheriff's departments that could go out and interview jurors or bring them to court. I mean, all these jurors are going to end up testifying anyway. There may not be any reason to go out and interview them. They may just put a subpoena on them, bring them to court.
How important is your appeal to get jurors to testify under oath in a place where, like you say, through the zone of silence, they have to go and talk to y'all before?
Go ahead.
Yeah, I mean, that's something that would happen if we get the hearing that we've requested. That's why we've requested the hearing, so that we can get subpoena power, and we can get some subpoena, not just individuals come to court, jurors come to court, witnesses come to court, but subpoena records, phone records, for example, emails, for example. I mean, so with a hearing, we have a broad array of assets at our disposal to bring evidence to court. Right now, we've got nothing except Dick's Mercedes and dirt roads in Colleton County.
Have you spoken to any jurors who reviewed what the other jurors are saying?
No, we've not had any juror contradict anything what the other jurors are saying. What you saw in some of the affidavits is the jurors were separated in two rooms and sort of broke up from, guys in one room, gals in another room. I don't know if that was appropriate. Men in one room, females in another room, and so the comments that we've gotten on the sworn affidavits come from the ladies' room, if you will, more so than the men's room. But we do have information that we submitted from one juror where he does acknowledge that she talked to him about evidence, about autopsy photos, and don't be upset about them. I mean, that should not be happening. That should not be happening. And this juror is a smoker, and he relayed to us basically the coercive effect of people who have a nicotine habit not able to smoke
until they reach a verdict.
Until they reach a verdict, and so that's what we got.
Wait a second. Yeah.
I had an issue with the cable at the very. Can you read that their initial motion to me real fast? Because I had an issue with sending.
Do what now?
The motion you read. Can you read that? The very first thing. I didn't catch it.
I mean, I'll read it for you after we get done with this, but I don't think I ought to keep all these folks doing that.
Would you request a change of venue?
Well, you got to get a new trial before you get there, and that's not something we're going to talk about today. And yes, ma'am. We know some of the statements were made in front of the jurors in the one jury room. Now, understand I think there are only 6 jurors in that room, or maybe 8. I'm not sure, but not all the jurors would have been present for all the statements. Clearly, they were given in one room or the other.
And just to be clear, the catalyst for reinvestigating this was publication of this book.
Yes, ma'am. Go ahead.
So we didn't stop investigating, but we were hitting brick walls until her book came out, and then jurors who
she wrote a book,
not comfortable with how she handled matters, were even less comfortable.
What book is this? The clerk wrote a book. Did the clerk write a book about the Murdaugh trial or just mentioning the Murdaugh trial? What is this book they keep mentioning? Is there a book on Amazon I need to get in my life? Does anyone know the name of this book? The clerk of the court apparently wrote a book. What did she write a book about? Did she pull a Biden and make confessions in a book she wrote?
With her going on a book tour and making money off what she did. That's what was reported to us.
she has said her book is self.
Behind the scenes of?
Really doesn't sound like somebody.
What is the name of this book? I gotta see this. Hold on. Behind the Doors of Deceit? Hold on, I gotta check this out. Behind the Doors of Justice, the Murdaugh murders? Hold on. Oh, no. Oh, can we read a sample? Oh. Oh, yeah. Hold on. Behind the Doors of Justice, the Murdaugh murders. Oh, my God. Wow. Wow. Becky Hill, Clerk of Court, Colton County, 2023. Wow. Wow. That's just special. Reading the verdict of a jury at the end of a trial should be as simple as reading from a third-grade primary school book. However, from my perspective as clerk of the Colton County Circuit Court behind closed doors, it was not going to be easy this time. I was very concerned, even conflicted, by professional relationships I had with the defendant, Alex Murdaugh, and the Murdaugh law firm, including Alex's brother, Randy. I had come to know the Murdaughs and the members of the firm I had served in my capacity as the official court reporter for 14 years from the South Carolina Judicial Branch, and then for 2 years serving as Colton County Clerk. I had known Alex for all these years, not only as a civil attorney, but also serving on the Earthside Justice in his role as assistant solicitor for the 14th Judicial District, comprised of Colton, Hampton, Jasper, Allendale, and Beaufort counties. But now, here we were in a horrendous double murder trial wherein the jury would soon be deciding the fate of Alex Murdaugh, criminal defendant. Wow. Although I was conflicted about knowing the Murdaugh families and about having so many people watching and listening to me as I read the verdict, I was most concerned about Alex being found innocent when I knew in my heart he was guilty. I had this fear that the goodwill the Murdaughs had built up over the community would influence the jury. Nice. After Judge Newman's jury trial, the jury was directed to retire to the jury room to begin deliberations once they received the exhibits in trial. It was Thursday, March 2nd, 2023. The time on the clock in the back room of the courtroom read 3:05. Unclear here what this author's view on the relationship between clock, chandelier, and seal is. She doesn't appear to say. At 6:20 p.m., only 3 hours and approximately 15 minutes after the jury had released a jury to deliberate, I walked through the courtroom and down the hallway, leading to the jury room, to ask my jury bailiff what the jurors would like for supper. A jury bailiff is seated outside the jury room at all times during deliberations. In short order, the bailiff relayed a message from the juror there was no need to order anything for them to eat, as the verdict was coming soon. This was unusual. Most murder trials take the time for the jury to reach a decision, but apparently the jury was satisfied they'd be returning to the courtroom shortly with a verdict. I was caught off guard. Their slight nervousness began to hold as I began to realize I'd soon be center stage, delivering one of the most serious, most important tasks of clerk of court, reading the verdict. Wow, this is special. Some might view this opportunity as a payoff moment in the clerk of court's career, a chance to be part of courtroom history. After all, one does not step into such a position without being a bit of a legal eagle. Blech. I had been a middle school teacher working in the state at local disability agencies, had held administrative roles in law offices for many years, and served as court reporter for the state of South Carolina before I announced my candidacy for clerk of court, and I was elected in November 2022. I put in the effort. While I'd always hoped to be part of history, I didn't foresee it being this way, reading a verdict about someone I personally knew. She's taking a lot of ownership of this thing, man. Holy God, man. Jeez, that's the... At some point, after all the planning and opening of the trial hit me, the troll of the trial had taken a toll on my health. I've been going 200 miles an hour. Early days, long nights, about a COVID-19 that knocked me out of the courtroom for a week. I was about to read the verdict with no clue what the jury decided. My read was going to be broadcast worldwide. That was huge. Deep in thought, I sat in my upstairs office, staring out the window, overlooking the front of the courthouse square. The sun had already set, and the darkness covered the town. I could see the courthouse flagpole with our American flag and our state flag flying and dancing in the wind. The light was shining on them, putting them on the spotlight. Would justice be done here tonight? Would we receive a verdict of truth? I mean, not to put too fine a point on it, but the word verdict, of course, literally means truth. Because verdict comes from veritas, which means truth. So verdict means truth. Okay. All right. Pressing on. But above what would be the end of a very stressful 6-month period of preparation and trial execution, I was about to read the verdict. I would not know until guilty or not guilty, until after Judge Newman had read it to himself and handed it down from the bench. In an instant, my mind broke away from these reflections and brought me back to the present. And just like that, I picked up my cell phone and dialed Melinda Nettles, my friend and mentor. She and her husband were the ones who encouraged me to run for Colton County Clerk in early spring 2020. As the clerk of court in a neighboring Hampton County, Melinda is also my trusted colleague. She's read hundreds of verdicts during her career, and she'd be the one who could truly emphasize with me. By the time she picked up my call, my heart was beating faster. I said to her, "I don't think I can read this verdict." In a sweet, nurturing southern drawl, Melinda said, "Honey, it's just like every verdict you ever read in court." I remember laughing and saying, "No, it's not. You just wait. Your time is coming." Sure enough, months later, my experience in the murder trial would help Melinda in her courtroom. As of the writing of this book, a wrongful death civil boat trial will be held in August 2023, the same boat trial that also involves the Murdaws. Melinda's pep talk helped me, but still didn't convince me I should read the verdict. When Judge Newman reconvened in court and brought the jury back in, I felt nervous again. I was used to reading charges against defendants who were involved in bar shootings, driving without a license, and drug deals. Regular, average kind of folk. But this was the Murdaws. This was life-changing. Life-changing for Alex and her whole family. Okay, this clerk of court has got some serious main character energy, man. Holy shit. I mean, this clerk of court has got to read the verdict, and she has got serious main character syndrome. Wow. I mean, they say everyone is the center of their own story. And this woman is certainly confirming that to be true, right? From this woman's point of view, the world does truly revolve around her. She is the main character, and she has got main character energy. She is the center of every story she's ever been in. And she really likes that fact, man. How many words can you write about? I mean, she literally has to get up and just read the jury verdict. How many words can you write about it? Apparently the answer is a lot. Apparently the answer is you can write a lot of words about it. Holy God, man. This is a lot. This is, wow. You know, at this point, I think I should author a story on behalf of Clock. My Time in the Courtroom, a clock's story by clock. I could tell the story of their view of the courtroom. I could tell their view of the story and the whole romance between them and Chandelier. It could be a multi-story, it could be a multi-chapter book. Do you think anyone would buy it? Do you think anyone would buy it? My Time in the Courtroom. My Time in the Courtroom. A story by clock. Clock has been in this courtroom for many years and has seen many things through the passages of its hands. But nothing it saw that day would affect it as much as it did between the blazing romance, between on the one hand, the murder trial happening before it, and on the other hand, the blazing romance happening in its heart. Wow. It's so sappy, I'm already in. It's so great. My Time in the Courtroom, the story of Clock. What I thought was once going to be just a murder trial turned into something more. As my paramour, Chandelier, started talking to Seal. Would I be the drama, the twin dramas happening in the courtroom, the twin dramas as told by only Clock, as only Clock could tell it. There is a story to be written. There is a story to be written. I don't know whether or not anyone would read it, but there is a story to be told. Yeah. Yeah. Yeah, there's a story to be told. Big time. You don't get the clock joke? Oh, I'm sorry. You missed out. I'm sorry. Yeah. People who are not here during the Murdaugh stream won't get the joke. I'm sorry. Yeah. We were so bored. We were so bored during parts of the Murdaugh murder trial that I, Uncivil Law, decided to start telling a different story. Because the cameras, when they weren't pointed, at things in the courtroom, had to be pointed at something, right? So what would the cameras be pointed at when they weren't, pointed at a witness or pointed at the judge or pointed at the defense lawyer, right? What would they point at? So there were 3 cameras, and they were point at the Seal, the Clock, and the Chandelier in the courtroom, right? When they weren't looking at anything else, because that's what they were point to, right? Because when they weren't pointed at something, they're pointed at the Seal, the Chandelier, and the Clock. And so I decided that Seal, Chandelier, and Clock were involved in a romantic tryst. And I started telling the story of the romantic tryst between Seal, Chandelier, and Clock, and how there was, a lover's quarrel and betrayal and, affairs and yelling and disappointment and heartbreak and everything. It became a whole thing. It became a whole thing about the relationship between these 3 entities. And, yeah. So that's the inside joke. Yeah. Yeah. So so I started just writing the story. I just started telling the story and writing the story about this love affair between these 3 and, all the rest of it. And yeah, great. Anyways, that's enough of that. So I could publish a story. Yeah, I could publish a story and publish it in behalf of Clock. About this romantic relationship in the throes of the murder trial. It is a John Grisham story waiting to happen. Time for justice Light of virtue, sealed fate. That's pretty good, Matt. That's pretty good. Yeah. So, all that stuff. All right, let's read some super chats and then wrap this stream up. Tammy Ellison gifted. Tammy Ellison became a member. $9.99. Apologize. 99 cents. Became a member. Thank you for hitting that beautiful, beautiful join button. Just remember, Uncivil Law isn't insane. He's creative. Yeah. Okay. Marion Griffin gifted 10 gift memberships. TMD gifted 10 gift memberships. New York Renal MD said, "Are we sure the prosecuting manager is a lawyer?" Well, if so, he leaves something to be desired. And yeah, I have questions. Yeah. Yeah. Although not much will ever beat the love story that was the Daybells. That was great. That was great. With the loin fire and the blessings, that was pretty good. That was pretty good stuff. So I do miss the Daybells because they brought to us some joy. Yeah. Oh, God's the blessings. Yeah, exactly. Right. Yeah. 100%. Right. Yeah. So. And the Holy Ghost. And this, yeah, it was a lot. It was great. All right. So let me go ahead and schedule for tomorrow, and then I'll just dump you into tomorrow's stream, and you can, mark it on your calendar. So let's see. I'm going to reuse these settings. Okay. All right. And this will be September the 6th. And this will be at 8:45 a.m. 8:45 a.m. Great. Schedule that. Okay. Then I need to go over here for today's stream and dump you over there so that you can save your place for tomorrow. Great. Outstanding. All right. So I will end the stream, and you guys can go over there and save your place for tomorrow, and also help me retweet as soon as the tweet is available. So, yeah. All that good stuff. So, I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.